Good morning, everybody. Happy Friday Eve. Welcome to the Courtroom Files Live. We never have enough Judge Oakley in our lives, so let's start there.
I think with the previous judge, there was a different attorney, and the set for British trial, so therefore waived his jury trial. But I was just requesting one, but just to put that on.
If he already waived his jury. Yeah.
Your Honor, is it possible to get a bench trial date for February,
Probably.
April? I mean, April,
This is a Angela.
Van Buren. Yeah.
Can do February 9th,
How's that?
the Monday.
February 9th, works.
What time?
So we'll do 11 a.m.
All right. 11 a.m. Okay. Bond is continued. We'll see you guys then. We'll get you a notice, Mr. Sharif. Am I saying that right, Sharif? We'll get you a paper notice.
Bench trial will be with you?
Yeah.
Okay. Okay.
All right. See you then. Nolan Crawford. You know, I still don't have my coffee cup back from Joe.
And I called him on it.
Good morning, Your Honor.
Oh, he put it over here. I found it.
State your name.
Good morning.
For Raymond purposes, we stand with the company resolution, the defective equipment will be expired.
Yep.
This will be reduced to allow, I guess, it's been first operating.
Got it. Mr. Crawford, you discussed your rights and options with counsel? Understood all that? You understand the possible penalty for the allowing? And understanding all of that, are you pleading guilty freely and voluntarily to that charge today? Were you driving a vehicle on November 22nd in Van Buren? And at that time, was your license suspended, revoked, or denied? I'll accept your plea to the added charge. Excuse me. Dismiss both original charges. What's the status of your license now, sir? What do you have to do to get it back? What do you have to do to get it back? Oh, good. Good luck. Are you working?
Who wrote no payment plans and why?
Maybe that means he's not on, he owes them money.
Thank you. Right. How long you been at U of M? Okay, new job. How's it going? Full time? They got good bennies, don't they? Yeah. Do they still have some kind of tuition break? Like if you wanted to take classes or something? Yeah. Well, take advantage of that. Yeah. Yeah. All right. Anything else you want me to consider before I sentence you today? You already owe us almost $1,000 on stuff from 2024 and 5. You know about that? Belleville, double parking, Van Buren speeding, Belleville allowing licensed driver to operate. Are you in a position to get some kind of payment plan set up? Weekly, bi-weekly, monthly, some kind of regular payments? All right. Anything else on today's file? All right, fines and costs on the file, $500. I'm also ordering 4 days on the court work program as an alternative to jail. I'm going to send you downstairs to schedule your work days and get some kind of payment plan on paper. Any questions? Good luck. Thank you. Gideon? Ma'am, are you going forward today without benefit of a court-appointed attorney? All right, looks like you met with the prosecutor. And looks like you're going to plead guilty to the added charge of allowing an unlicensed driver to operate a vehicle on October 11th in Van Buren Township, and the original charge would be dismissed. Is that your understanding of the deal? Did you read your rights form? You understand those rights and the options presented? You understand the possible penalty for the added charge? Understanding all of that, are you pleading guilty to the charge freely and voluntarily? Did you drive a vehicle that day in Van Buren? And was your license improper or invalid that day? What was wrong with your license then?
My permit, I go tomorrow to take my road test.
Good luck. And are you working? Where do you work?
Here with assisted living.
All right. Anything you want me to consider before I set the terms of sentence?
Just there's a no insurance ticket on there, as a bar long driving.
Let me look. Let me look.
Or working, I think with HR is working. Okay,
I misread the ticket, so I thought whenever it said that you guys would notify me, it would be for the other tickets as well.
There's a speeding ticket too, right?
I tried to come up here to say it, but it wasn't really system due to the holiday. So on it.
okay.
Hey, Angela, can you talk?
Yes, Judge.
Miss Gideon screwed up. You made a deal with her on a drivable license not valid, but she picked up 2 civil infractions that she got defaulted on because she thought we were gonna let her know on those too.
Yes, Judge,
you-
she explained that. I don't have an issue with dismissing those if the court's agreeable to setting the default aside.
Merry Christmas.
No, like stay over the.
Thank you, Miss Manarino. Yeah.
You're
All right.
welcome.
That's huge. That just saved
Thank
you
you, Judge.
$450 and points.
Appreciate that.
All right. So you get that, Heather? Set aside the default on the civil infractions?
Is the piece of paper on the front?
Yeah, yeah. All right. Okay. Well, that's nice because I don't feel so bad now because I'm going to charge you on the misdemeanor. All right. Actually, I'm going to blow your mind. I just saved you $450 because I was smart enough to call her, right? On this file, it's $500 or show me a valid license, right? Merry Christmas.
Wish me luck on my parallel parking, because that's.
Oh, you better practice today. It's a $500 parking lesson. 550, because that's your total, 550, you had a late fee. All right, and I'm gonna give you until next Friday to get in here.
And I can just come in and show the clerk, or,
Yep.
thank you, I appreciate that.
All right, so I just gave you lots of grace, didn't I? What do you do when somebody gives you lots of grace? And you pay it forward. Find somebody to do something nice today. Tis the season. Good luck tomorrow. Lakina Shepherd.
Words of wisdom to start our day from Judge Oakley. I so wholeheartedly agree with what he just said, and society needs more of that. So I'd throw that challenge out to all of you today. Have some grace for somebody. Have some compassion. Pay forward a good deed today. Good morning. Welcome to the Courtroom Files Live. Happy Friday Eve to you. Let's continue with Judge Oakley for a while. He's in a good mood.
But it could impact your ability to drive legally. You understand that? And you understand your rights?
Yes.
All right. And are you going forward with the guilty plea? I'm not trying to talk you out of it. I just want to make sure you're going in with your eyes wide open. The way this can work is if you're currently suspended for a year, for example, and we tell them that you were driving, because when we do the disposition, we show them that you were driving on December 23rd. So that could trigger an added suspension period to that 1 year. No guarantee that it will, but I just want to give you a heads up, it might.
Okay, wait, get everything straightened out, I'm curious, only thing I gotta do is take a little bit.
But this is going to tell them that you were driving when they told you not to. So that's what they hang their hat on if they penalize you. Right? Anything else? Okay. So did you in fact drive a vehicle that day in Van Buren Township? And your license was suspended, revoked, or denied? Okay, I'll accept your plea. You've already posted some money, right? Okay, and when are you taking your test? Took it Friday, tomorrow. A lot of testing going on tomorrow. Good luck. All right, are you working? Where do you work? How long? All right, anything else you want me to consider? All right, we got some late fees on this one. Let's see what we got. No, it looks like you, is her bond forfeited? Oh, she got a new bond. Okay. Yeah, it looks like she had a bond. way back in 17, lost it, and then she got a new bond from 25. Okay. All right, we've got a lot of money out of you already. $500 fines plus court costs. We'll apply the 150 current bond. We'll apply that. Can you pay the balance today, or do you need some time? All right, go downstairs and talk about options. Any questions? You're all set. You're welcome. Smallwood. Ms. Smallwood, are you going forward today without benefit of a court-appointed attorney? All right, looks like you're going to plead guilty to fail to report an accident. I'll dismiss leaving the scene of an accident, and you're going to plead guilty to no valid operator's license. I'll dismiss drove while license suspended. That's a deal? Did you discuss, or did you go over your right, or look at your rights form? Understood the rights and options you have? You understand the possible penalty for these two charges? And understanding all of that, are you pleading guilty freely and voluntarily? Ma'am, did you drive a vehicle in Van Buren Township on April 25, 24? And were you involved in a motor vehicle accident? Did you fail to report that as required by law? Or did you leave the scene of the accident?
I didn't realize what happened because I didn't.
So when you say you didn't realize what happened, you mean you didn't realize you were in an accident?
Well, no, I didn't get in the accident, but the car did. Yeah, sure.
The car got in the accident without you? Okay. All right, so you got out of the car and it kept moving? Okay. Okay. All right. And at that time, was your license suspended, revoked, or denied? All right. And you understand that the no valid operator's license on person charge could result in a greater suspension period? You understand that? All right. Anything else you want me to consider before I sentence you? These are old files. Where you been?
Pardon?
These are old files. Where you been that we haven't taken care of these already?
I was precariously housed for some time.
Okay.
The place I
Bigger fish to fry?
I was in a bad situation.
I got you.
Left that situation.
More stable now?
Pardon?
Things more stable now? Yeah. Are you working?
Yeah, it just got me.
Okay.
I'm in bad space.
Yeah. Where are you working at?
We all went to work, throwing away, and I didn't know I was supposed to.
Okay.
Right now I'm helping, one of my friends at a shop that only part-time.
Part-time? Okay. So you're looking for work?
Yeah.
And you're living, all right. And the Ipsy address a good one? All right. So before you get out of here, ask somebody downstairs where Mr. Taylor is, Avery Taylor. Talk to Avery Taylor. Tell him you're looking for a job because he's got a list of area employers that are looking for work. Okay. So yeah. I don't know. Maybe it'll work, maybe it won't, but it'll be somewhere to start. All right. Anything else before I sentence? All right. All right. And you've got bond posted on both files. All right. On the accident charge, I'm just going to take your bond and close it. And on the no operator's license, I'm going to do the same. Merry Christmas. You're welcome so much. Better days coming, Miss Smallwood. All right, go downstairs and talk to Avery. That's all you got to do. Good luck finding a job.
Wahoo, thank you for gifting a membership. Very much appreciate that. Thank you so much. Let's head down to Florida. Wade Mercer. We'll see how Florida man or Florida woman in this case is doing today.
Ms. Jenkins, good morning. Ms. Jenkins, you're here because you've been accused of two things. You've been accused of one count of possession of methamphetamine and one count of possession of paraphernalia. Ma'am, I have read the complaint. There is probable cause for the charge, ma'am. I'm also looking at your criminal history now. I did not have time to do that earlier, and I do see the warrant.
Yes.
Do we know
sir.
how Corporal, do we know if Ohio wants her on this charge or not?
They do not want me
I
there.
don't believe they do.
The case was supposed to be dropped.
Okay, so Ms. Jenkins, normally they don't come from Ohio and get you unless it's something they really want you for. It's just kind
Yes,
of a
sir.
cost benefit analysis. If it's a misdemeanor, the chance of them to come and get you is slim. It's a serious felony. It'd be a different
Yes, sir.
analysis. So I'm going to see if the attorneys have any additional information, ma'am, then I'm going to set your bond in this case. Mr. Mitchell, anything from the state?
We just request you be subject to random UAs.
Thank you, Mr. McDaniel. Ms. Jenkins, I'm going to set your bond at $5,000 on the felony charge, $2,500 on the misdemeanor. Ma'am, your total bond is $7,500. Well, was the misdemeanor, was the paraphernalia packaging or was it some kind of pipe?
It was a pipe in packaging,
So if it's just packaging, I might set a little lower. So that'll be your bond, ma'am. It's $7,500 cash or surety. That means you can go through bonds with Ms. Jenkins. That's based upon a variety of factors, including your criminal history. Ms. Jenkins, you do have a condition of random urinalysis. What that means is that that judge can instruct or ask a law enforcement officer to drug test you at any time, ma'am. So be aware of that. If you test positive for something that you don't have a valid prescription for, that likely would violate your bond and you would go to jail with no bond. Ms. Jenkins, I'm also going to ask the jail to give you notice for your court date. Are we still on the January 6th cycle? January 6th will be your court date at 8:30 a.m. and Corporal Campbell will give you that notice, ma'am, when you get through with first appearance. Ms. Jenkins, do you have any questions?
I do not.
All right, man. Wish you the best. We have Charlie John Beagle next. Mr. Beagle, good morning. Mr. Beagle, you're here because you've been accused of 3 charges. They are lewd and lascivious exhibition using a computer, traveling to meet a minor, and interference with custody. Let's see if I've got a copy of the warrant. It's not included in this packet. So, Mr. Beagle, give me a second. You were first appeared yesterday, and I believe from the notes I've got the judge covering did not set a bond yesterday. Is that correct, Corporal?
Yes, sir.
We have an affidavit, so I asked the jail to send the affidavit to you.
Okay, so that's concerning to me. He didn't get a bond because there was didn't have a complaint? I don't have a warrant. Do y'all have a warrant at the jail?
Yes, we do.
Yesterday.
We sent it up yesterday to the courthouse and we sent the complaint today. But
I just want to make sure that, I just want to make sure for future reference, if the officer didn't file the complaint with the clerk's office, that's a problem. Do you know what happened?
He did.
He filed it.
System, but he did not take a copy from the clerk's office out there that had the case number wrote on it. He just pulled the one without the case number signed.
So what the judge got was,
Just the warrant.
okay. So, Mr. Beagle, I've read the complaint because I was the judge that signed the warrant to begin with. When it was presented to me within the last few days, I signed the warrant. That's how I know there's probable cause. I'm also the judge that looked at your prior criminal history and saw a sex offense as a juvenile that you were convicted of, and I believe sent to a detention facility. And I don't know if the judge yesterday was aware of that or not.
He didn't see anything. We couldn't see
Okay.
anything. He couldn't see anything. So.
So I'm aware of that juvenile charge. He has no adult history, but Mr. Beagle he's only 19 years of age, I believe. So Mr. Beagle, let me see if the attorneys have any additional information, and then I'm going to look and see what degree all of these crimes are, because some of them are crimes we don't deal with very often. Mr. Mitchell, on behalf of the state, anything in this case?
I mean, we just request you take into account that his juvenile history for the sex case in that matter, and give him a reasonable bond under those circumstances, with the condition that, he not have access to the internet except for like bills and utilities or those essential type things.
Thank you, Mr. McDaniel.
Just take into account that the case of when he was a minor was a totally different type of case. This is a 15-year-old and 19-year-old, and I'm not trying to say it's okay. I'm not trying to say it, but just take into account that it's an entirely different type of case. It's not the same kind of thing.
Have you had a chance to look at the other one?
I did.
Okay. And I agree. It is totally different. What's concerning is he had such serious charges, and it does not appear he learned a lot if he's allegedly dabbling around with this young lady he's accused of. So it looks like the lewd and lascivious exhibition is a second degree. The traveling to meet a minor is a second degree. The one Well, the Luna Civics exhibition using a computer is a second degree. That's the one I don't see very often. The using a computer part. I did not know that was a second degree. The traveling to meet a minor is a second degree, and the interference with custody is a third degree felony. So he's got 3 felony charges. Is that really a second degree? Using a computer, that surprises me. So let's go look at that statute real quick. We've got time. We'll make sure we do it right here. So let me make sure that's a second degree, because that's definitely going to affect the bond I set. If it is really a second degree felony, it's 847.0135 is the statute number. If it's true, that means that whether there's a computer involved or not, it's the same degree crime, which is a little bit surprising. 847.0135. That's not the right statute number, I don't think. Maybe it is.
Section 6.
Well, the warrant says subsection 5. Is that a 5 or a 6? It's a bad copy. Is that a 6?
I'm looking at the complaint. It looks like a 6. It may be a 5.
Yeah, it's a 5. When you look down below on the warrant, it's a 5. The top one is bad. So in subsection 5, ooh.
Under 18 years of age or older.
Yeah, it does say, but it also requires an act that I don't remember being in the complaint. I thought it was just a picture in the complaint. Let's see. I'm looking at the complaint now, so give me a second, please. Okay, this charge that he's accused of, let me be more specific. The one count he's accused of, lewd or lascivious exhibition using a computer. Florida statute 847.0135 subsection 5 requires a person who intentionally masturbates, exposes the genitals in a lewd and lascivious manner. That's the theory they're going under, because allegedly he sent a photograph of himself. So there is probable cause for all 3 charges, Mr. Beagle. The good news is you're entitled to a bond. I'm going to set you what I think is a reasonable bond, taking into account all the factors that I've been presented. Mr. Beagle, your bond on the 3rd degree felony is going to be $5,000. Your bond on the 2 second degree felonies is going to be $15,000 each. That means your total bond today is $35,000 cash or surety. A cash or surety means you can go through a bondsman, Mr. Beagle. You don't have to come up with all the money. You can go through a bondsman if you wish, and you have that right and that option, Mr. Beagle. You also going to have a condition of no contact with any minor at all. You don't have children, do you, Mr. Beagle?
No, sir.
Okay, so no contact with any minor at all. And the state's made a request that I limit your internet access. The state's request was that it be limited to anything other than paying, I think you said paying bills.
Yeah, we've had something similar like that in the past for the conditions where it's like bill pay or utility pay, but no access to the internet for anything else.
Are you in school anywhere, Mr. Beagle?
Not yet, sir.
Are you employed anywhere?
Yes, sir.
Where do you work at?
Burford Construction. We work all across Florida, doing tree work for FBO.
Okay, so Mr. McDaniels, you want to be heard on the state's request regarding internet access or limited internet access? My consideration would be work purposes and paying bills online. That'd be it.
Mr. Beagle, is that all right with you? You stay off the internet except for work purposes or for bill pay, or some kind of business application or business stuff that you have to do? I know sometimes you have to do stuff online, but just essentially stay off of any of those chat things is what we're saying, or anything to do with any of those things, unless it's work related or business related.
Mr. Beagle, I'm going to do that. I know that Mr. McDaniel asked you your thoughts on that. I'm going to do that anyway, based on the charges and your history. So you cannot use the internet except for work purposes or paying bills online. That means no social media accounts, no tweeting and Facebooking and all that kind of stuff. None of those other websites that do similar features, Snapchat. What else? Mr. Gibson, you're into that kind of stuff. What? Instagram, you know about all that high tech stuff. I don't either. I don't have them either. So none of that kind of stuff. Now you can use text messaging, but it can't be to a minor. No contact with any minors at all, because the type of charges you're facing. Those are intended to be temporary restrictions. We'll see what happens with the case when you get over to felony court, Mr. Beagle. You will get to use the phone today because your bond has changed since yesterday. You'll get a chance to use the phone and try to post the bond, contact friends or family. Mr. Beagle, the jail's going to give you a notice for your court date. Your court date will be December 6th at 8:30 a.m. That's when you'll be a court date in front of Judge Garcia, and we'll see where the case goes from here. But you have the right to post bond immediately, and if you post bond, you'll be released. You just have to be back on that court date. Mr. Beagle, do you have any questions?
No, Your Honor.
I didn't say, I don't think I said no contact. I said no contact with any minors. Obviously, there's a condition that includes the alleged victim. No contact with the alleged victim at all. I'm sorry, I didn't mean to interrupt you. Do you have any questions?
No, Your Honor.
All right, wish you the best, sir. Corporal, anything else from Mr. Beagle?
No, sir.
Thank you. All right, so Mr. McDaniel, Mr. Mitchell, that was all I had on the list for today for first appearances. So let's see if I missed anything. Just start.
Well, that might have been all he had on the list, but that was probably enough. Disturbing young man, in my opinion, allegedly. The fact that he got his first sex-related charge as a minor does not bode well for his future, but I guess we'll see what happens. We'll keep an eye. If he's going to felony court, he could end up in front of Brantley Clark or Anna Garcia. We follow both of those, so we'll see what goes on. Let's go back to Michigan. We'll say good morning to Judge Middleton, change up the pace a little.
This is file 252127, People versus Chase Michael Deli. Here with his lawyer, Paul Gibson. Also present is prosecuting attorney assistant Angelique Canfield and their victim advocate staff with the original complainant, Amanda Hunneman. The defendant was charged with domestic violence second offense. It was reduced to first offense, and the matter was set for sentencing today. We're in the matter of People versus Chase Michael Deli. Some people say Dell. It's Deli, correct, isn't it?
Deli, yeah.
File 252127. The case originated on September 5th. The defendant pled on December 9th. There were no contact provisions in place. I lifted some of them, and the matter was set for sentencing here today. So, Mr. Gibson, what would you like me to know?
The defendant indicates that he is employed through a family business, Flores Painting, and he's been there for approximately 3 years. In this situation, the defendant was proactive, you could say. He and his fiance have been going to counseling sessions, and he has obviously had some very stressful and difficult times in his life over the past several years. There's been various incidents that the defendant's been involved with, including being stabbed and having family members and other people pass away in his life. And he's also indicated that he recently reached out to Pivotal because he would like to start individual counseling sessions again that he did in the past. So the defendant, I believe the defendant has, demonstrated that he can be supervised on probation. I don't believe he's a danger to society. I believe that the victim in this case indicated that she doesn't believe that she was a victim of a crime. And so I believe she's asking for leniency. So I would ask the court to consider a probation term or some other type of resolution that does not involve jail time. Thank you.
Ms. Canfield?
Your Honor, I'd like the Ms. Honeyman to be able to address the court first.
All right, thank you. Why don't you just have a seat there next to the prosecutor? Good morning. You're Amanda Honeyman?
Yes.
All right. And Mr. Gibson referred to your comments in the victim impact statement where you felt you had not been a victim of a crime. What would you like me to know?
I just would like you to know that in this particular situation, it may be easy to instantly look at him as the aggressor, but it actually was the complete opposite. I was the one screaming.
What were you upset about?
I couldn't tell you.
That's so common. Now, you had an earlier incident in 2024 where
That
he
was a
was,
completely different.
all right, he was convicted of domestic assault by a plea. He pled guilty. He did the deferral probation and successfully completed it.
Mhm.
But I'm trying to understand the whole circumstance here. Who is Tina Hart?
She is the tenant in my basement. I have a court date tomorrow over Zoom about her.
All right. I thought who owns the house? Maybe I got it backwards. I thought she was evicting you.
No.
Yes. So you own the house on Coolwater Lane
Yes.
and she's in your basement. She won't leave. And you're selling the house. You and Chase live at that same house. Now, who owns the house? You do?
I do.
All right. Is Chase on it as well? So you own it alone? And he lives.
He lives there and pays the bill.
All right, but it's in your name.
Yes.
And this lady won't move?
Right.
Where are you moving to?
Union City.
With Chase?
Yes. The house will still be in just my name though.
Okay. Why Union City?
To get out of Colon, because I've lived there for my whole life.
Some people like it in Cola.
Some people.
All right. Well, that's tough when you've got a tenant that chooses not to move. Does that person did they originally pay any rent?
I've seen $500 one time since August, and that's it.
All right, well, we'll deal with that tomorrow in the context of the landlord tenant case. All right, well, Chase did probation and he successfully completed. In fact, I think he's done more than one probation, but he completed the domestic violence, went to the anger management. Let me ask the more recent incident, was alcohol involved?
Yes.
By both of you? Yes, there's been an alcohol undercurrent to your relationship.
Yeah.
And some of his problems. What is going on in that regard?
We stopped drinking completely, actually pretty recently after that incident, so probably like second week of September. That was kind of the breaking point where, you know, we need to stop. Realization.
All right. And at this point, he's the father of your child. You want to reunite as a family unit and you don't wish a no contact provision.
Correct.
All right. And you're trying to evict your tenant out of the basement.
So I can.
All right. We'll see how that goes tomorrow. All right. Having heard that, Ms. Canfield, what's your position?
Thank you, Your Honor. I've had quite a lot of contact with Ms. Henneman since this case began. one of the reasons that they are engaging in the counseling was at my suggestion as something that they could do to resolve this in a fashion that didn't involve jail and would lead to a better, stronger relationship for both of them, since she did indicate they intended to remain together and get married, and they do have a child together already. I do not seek any jail time at this point. I think a short term of probation with a continuation of the marital counseling they're already engaging in, and then some sessions, as the defendant had indicated he wanted to go to pivotal, could be very helpful to them and find some costs.
Mr. Deli, you and I have spent a lot of time together in the last couple of years. Both of the time you got stabbed and these other incidents. I think Amanda's point that alcohol was interfering with your whole life. So you just stopped drinking?
Yeah, like it's not hard. Like, can I say about that night was what really started the argument was me saying we're done, and I dumped the beers out, and that's when she got a little upright and a little mean. But like, I haven't drank a drop, and there's no issue with it. Like, I don't really need it. Wasn't a need or a want. It was just something that I did on a daily basis or weekly with dinner. Like, and now it's just drink a lot of water and a lot of soda, which is not as good, you know, but.
All right, I'm gonna do a short probation as the prosecutor requests. I want to make sure you finish your marital counseling and that you do sign up with pivotal. That stabbing incident, there were different versions of what all went down, but you did get stabbed.
Yeah.
And it was because of some bad blood with some other guy, which just a lot of drama in the little village of Colon. All right, I'm gonna order 10 days jail credit 1. Of the 10 days, 9 are deferred. You're not gonna do any more jail if you do what I ask you to do. Everything that I assessed as a fine is less money you have for your family. Nonetheless, there's a $75 fine, a $75 crime victims' rights fee, a $50 state minimum fee, and a $240 probation oversight fee. I want you to continue counseling. Sign a release. And follow through on pivotal. No assaultive behavior, no drugs, and no alcohol. Test as directed. We're gonna do a little 6-month timeout. And I wanna make sure that there's no alcohol, continues through Christmas and New Year's. You continue with your marital counseling. There is not a no contact provision. You're allowed to live in the same house. I looked at the house on Zillow. It's a very nice home.
Yeah.
The offer seems like looks like a bargain to the purchaser, but I see that you want to get out of it. And
Yeah, it needs some work. There's got some.
does it have lake access?
Yeah, it does.
Well, I know Dr. Melendez's old house,
Okay.
I believe. There's 9 doors that lead outside upstairs.
So it's got a lot of, probably hard to heat it. All right.
Breezy area.
All right. I think you're gonna be okay. I've seen you do well, like with that probation, and I've seen you do not so well. But if we can take alcohol out of the equation, everyone's gonna be better off. Who is doing your marital counseling?
Sue English, I'm not sure how to pronounce.
Out of
her
where?
last name. Life Stance and Portage.
All right, this should go pretty smoothly. All you gotta do, no more criminal activity, no assault or threatening behavior, no alcohol. Continue with the counseling that you're already doing, and you ought to be able to hold that up for 6 months, and then I'll feel more comfortable just taking my hands off the wheel here. So I wish you both luck. I hope I don't see you anymore, at least not in here. Oh, I didn't add up that money. Let's do that.
440 maybe?
No, I think it's 350 plus 240. 590. Could be reduced if the probation is done early. I have a surety bond, so I don't have any money that I can apply to this. Doing 6 months. All right, you're good to go. Take that down to probation. And I hope things go better.
The question is, will we see them again? Put a 1 in the chat if they'll be back in court. Put a 2 in the chat if they're finally all done. Let me know what you think. Let's go to Lake County, Ohio. Judge Collada, if I heard this correctly, this is a few minutes in the Wayback Machine, but I believe somebody is going to file for ineffectiveness of counsel. Let's see what that's all about.
Your Honor, we are here on the matter of the State of Ohio versus Elizabeth Ewing, case number 25 CR 000858. Defendant is present in open court with their attorney, Chad Mulkey. We are set today for a change of plea hearing. The state has extended an offer for the defendant to plead to the sole county indictment, aggravated possession of drugs.
I immediately correct myself. That is not what this hearing is, but we'll stick with it anyways.
Assessment, and there is no agreement regarding sentencing.
Thank you, Mr. Mulkey. Is that accurate?
Yes, Your Honor.
Ms. Ewing, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here this morning?
Yes, Your Honor, I heard every word.
They've indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty and plead guilty to the charge in the indictment. And I'll go over that with you to make sure you understand what it entails. We would then continue the sentencing to a future day, get some evaluations completed, come back on a future day. Where there's no agreement between the parties regarding any recommendations for sentencing, each side is allowed and permitted to recommend whatever they think is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, and most importantly, what you want to do today?
Yes, I understand.
That's what you want to do?
Yeah.
Well, before I can accept your plea, I need to make sure you understand everything that's going on here. You need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'll ask you a series of questions. If at any point when I'm asking you any of these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer so you can ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything we're doing, all right?
Okay.
All right. Let's get started.
I'm going to go ahead and move out of that because it's going to be pretty pedestrian. I had the right hearing queued up, but I think it fast forwarded on me. So apologies for that. I'm going to try to find that though, because it sounded interesting. So we'll come back. But in the meantime, let's go to Judge Simpson.
Between this honorable court and the prosecutor's office on any and all matters this morning, Your Honor.
The court for its part also does not believe there's conflict either in the Michigan court rules or the cases decided there under. To the extent of conflict does exist, to give waivers, the court would consent to hear the matters. Court does call the case of the People's State of Michigan versus Ryan Joseph Milligan.
Yes, sir.
Good morning, Your Honor. Hannah Mackey requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Tortial Fees.
Practice is good.
Good morning, Your Honor. Ashley Schultz for the people.
Your Honor, we tried to set up a meeting with Mr. Milligan, but Jackson County was not accommodating for Zoom, so it looks like we're gonna have to be in person to meet with him. So we're requesting to adjourn this matter.
All right. Mr. Milliken, can you state your name, please, sir?
Ryan Joseph Milligan.
All right. And you heard all of that, sir?
Yes, so you guys are going to have to put me on a writ.
Pardon?
You have to bring me into court.
Well, no, what we're going to do is we're going to adjourn it. Your attorneys are going to meet with you in person. And
Okay.
so then hopefully the next time we get here, we'll be able to have a productive hearing.
Yes, sir. Thank you, Your Honor.
I like that. How much time?
3 weeks, Your Honor.
Pardon?
3 weeks after,
Weeks?
yeah.
After the holiday? You want the 8th or the 15th?
It doesn't matter.
Probable cause conference will be adjourned to, why don't we do January 15th, just to make sure? 2027, 2026. I don't know where that even came from. 2026, 9 a.m.
Thank you, Your Honor.
Fine, we'll continue.
Mr. Milligan, we'll be in there to see you soon.
All right, thank you.
Thank you, sir. Court does call the case, People versus David Merriquin.
Fellows for the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Merriquin, who approaches. Mr. Merriquin, can you please state your name for the record?
David Merriquin.
Go ahead.
In your honor, we are just seeking to waive today. And I did provide an order for release to treatment to the court.
Yes, it doesn't include a couple of things. It doesn't include a GPS tether.
Okay.
On this order. So I would order it so I can sign it after the waiver.
Certainly.
But, I need it where it would indicate that there's a GPS tether there, unless there's some objection from the people as to that order.
No, that would be the request of the people as well, Your Honor. Thank you.
I will revise that and send that to the court with.
All right. Your name, sir?
David Merriquin.
All right. You're waiving your right to have a preliminary examination?
Yes.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed, or the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing, see the circuit court for further resolution.
Yes.
People also waive the right
We do, Your Honor.
preliminary examination having been waived, defendants found over the circuit court on the single count.
Your honor, we acknowledge receipt of information, wait formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
January 6th at 1:30 with Judge Cummings.
January 6, 2026, 1:30, Judge Cummings.
All right, thank you very much. I'll get both of those persons today for you, okay?
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Brandon Dempsey.
Ready, Your Honor. Mr. Dempsey's in the hallway.
Okay, that doesn't help me, but okay.
Because of no contact and some of the people are in the courtroom. Your Honor.
Gotcha.
Assistant prosecuting attorney on behalf of.
Wow, that is red. Between you and Apple, what's this, like a Christmas thing?
No, we're starting a used car lot.
What?
Ken and I are starting our own used car lot.
Okay. All right. Oh, back I have one of those guys that will, anyway.
Good morning, Your Honor. J. Grant Miller, P58658. Please state your name.
Brandon Dempsey. Thank you. Yes, you may.
Okie dokie. Well, he's muted. I've got the colada thing queued up now. It did fast forward on me, so apologies for that earlier. But let's go back there and try that again.
All right, we are present in case 25 CR 508. This case is captioned State of Ohio versus Corey Hitchcock. This court received correspondence from Mr. Hitchcock contending that he wanted to file ineffective counsel due to multiple arguments and wanted to get a new lawyer. Court caused this correspondence to be filed and set the matter for a hearing. Mr. Hitchcock is here in court. He's with his attorneys, Ms. Nicole Novotny, as well as Mr. John Fatika. State of Ohio is represented by Mr. Nick Geigerich. All right, Mr. Hitchcock, you filed this request, so tell me why it is you think you deserve to have another lawyer. You got two of them right now.
Because they're not doing their job correctly.
Tell me what they're not doing.
So I've asked multiple times for a suppression hearing, and they keep denying me to file a suppression hearing when my rights have been violated on this case. My Fourth Amendment has been violated, and they think that there's no suppression hearing.
Is that it? This is your opportunity to put on there whatever you want to put on the record as to why you believe they're ineffective and you need a new lawyer.
Every time I have a conversation with Ms. Novotny, we ended up in an argument.
It's Novotny.
Novotny, my bad, I apologize. Every time we have a conversation, it either ends up in an argument or just feels like there's a lot of tension between me and her for some reason. And I don't think it's good for me to have her as a lawyer if she's representing me with the type of what is it? Like I can't even say the words right. I don't feel like she's doing her job correctly with all the arguments and the tension between me and her.
Anything else?
No.
So the centers around the suppression issue that you contend there is?
Yes.
I know I read your motion, and you believe that your Fourth Amendment rights were violated during the traffic stop because the officer called you someone else's name while trying to arrest you, so you pulled away, making you resist arrest. That's the violation?
Yes.
All right, well, that's not a violation. It's not a Fourth Amendment violation. It's a fact you could present at a trial, perhaps, to explain maybe why you acted the way you acted, but it's not a constitutional violation of your Fourth Amendment rights. And a lawyer is not allowed to file frivolous motions. There has to be a basis, a legal, lawful basis for a motion. She or Mr. Fatika can get in trouble if they file motions that there's no lawful reason to support. So just because the client says, I want you to file a suppression motion, doesn't mean they have to jump at whatever you ask them to do. If there's no lawful or legal basis for them to file this, they're committing an ethical violation if they do it. And if your grounds are that you were called a wrong name, which made you jump away, and that's the reason you resisted arrest, that doesn't make any sense. It's a fact that could be presented as a defense, maybe at a trial, but it doesn't violate, I'm not sure how it doesn't violate your rights in any way. And for them to file a motion making that argument would be an ethical violation on their part if they did that. Ms. Novotny, do you want to address this issue? I mean, Mr. Hitchcock raised this in a public filing, so you're permitted to address this issue and whatever else he alleged here today.
I mean, Your Honor, with regard to the arguments, we haven't had much of a productive conversation with that respect. I know we went for a jail visit on October 21st, and that was productive. Kind of went over everything in discovery with that respect and what we've seen. That's when that suppression issue was brought up, and we told him that it would be frivolous to file anything, so he's been informed of that. We also went to a jail visit on November 12th, which our visit was denied by Mr. Hitchcock. Ultimately, since then, our correspondence has been through letters, and numerous letters at that, just updating him on his case, which I have in front of me right now. So we've been in constant contact.
So you've only met one time because he refused any other contact.
We met him on November 12th, sat down, told us they didn't want to see us anymore. So then it was denied, the visit was. So other than that, we've been corresponding.
There's this tension he talks about. There hasn't even been any meetings for there to be this tension.
We have been denied.
Well, Mr. Hitchcock, you have the right to have a lawyer appointed to represent you. You don't have a right to pick and choose who your lawyer is going to be. Both Mr. Fatika and Ms. Novotny are very good lawyers. Mr. Fatika's been doing this a very long time. Ms. Novotny's been doing this a long time as well. And they're very good at what they do. they don't need to, they're not required to, and they're not allowed to jump and do whatever it is you ask them to do if they're not allowed to do that, or if it's an ethical issue. And this is what you're requesting them to do, will be a frivolous motion. Now, you may think because you were here before and you successfully had a motion to suppress that that's going to happen every time. That's not the way it works. There's no grounds that you're presenting me to indicate that they're not doing their job. They're doing their job the way they're supposed to do it. If you don't want to work with them, you don't want to meet with them, that's a choice you're making, and then they'll have to do the best they can do then without your input and your cooperation. I suggest that you meet with them, you work with them. They're here to represent you to the best of their abilities and to do what they can. But they can't do that if you're going to refuse to meet with them. You've met with them one time, and that was it. Go ahead.
I've met with them one time, and then the second time I didn't want to meet with them because of the attitude and the disrespect that they gave me.
When did they give you this attitude and disrespect?
The first time I seen them in jail.
An October date that she said? When you went over to the discovery and everything?
Barely even went over to discovery. I read the discovery briefly, and she's had the discovery since April. It says it on the paperwork. So therefore, how do I have any time to look at it? I've had a month max.
Well, you haven't been here. You've been in federal custody, haven't you?
Yeah.
So how's that supposed to work?
I was out on the streets before that.
Did you contact them and say, "Okay, make an appointment, can I come and see you guys?"
I've had a bond and everything. I've seen her before.
So did you make an appointment to meet with them when you were out on the streets?
No, she's never contacted
No,
me or called
did you, you're not listening to me, did you make an appointment, contact their office and say, "I'd like to come in and talk about my case with you"?
No.
Oh, okay.
I didn't have their phone number. I didn't know exactly who my
Do you know what the internet is?
I'm not savvy with the internet.
You can't just go on the internet and look at you're not savvy with the internet. You can't find the Lake County Public Defender's Office. You've been here before.
Yeah.
You've had them represent you, right?
But I didn't know who my public defender was.
You go to the office and you find out. You call them up on the phone and you find out.
I didn't know how to do that.
Then, what you want to say at this point, Mr. Hitchcock?
No.
All right, your request for a new lawyer is being denied at this point. This matter is set for a trial January 6th.
It's fine. I'll just buy a lawyer.
Sorry?
Sit down. I am.
What'd you say?
I'll just buy a lawyer. It's fine.
You just what?
So I'll purchase a lawyer. That's fine.
You're going to purchase a lawyer?
Yes.
Look at their piece of property?
No, I have family members that.
All right, well, tell whoever it is that you purchase that they're going to trial on January 6th.
Of course.
It won't be continued. So that is 2.5 weeks, 3 weeks from Tuesday. We need to know by this coming Tuesday whether you're going to accept the state's offer or not. So your purchase lawyer will have to contact this court by December 23rd to say whether it's going to be a trial or whether it's going to be a plea. Is there an offer that's been made in this case?
I do believe I gave him count one, Your Honor. Yes.
Give me a second.
And the other thing is, Your Honor, I'll be out of the office from the 23rd on. So it's, as far as I'm concerned, I'm just going to subpoena, I'm getting ready for trial.
Well, probably should. So the state made an offer to you to plead to count one, they'll dismiss count two. We need to know by next Tuesday whether that's being accepted. So if you have a new lawyer by then, they need to let us know that. If you don't, you need to let Ms. Novotny or Mr. Fatika know whether you want to accept that offer or not. Otherwise, we'll be going to trial on the 6th. Yes?
What is the offer exactly?
The offer is plea to count one, aggravated possession of drugs, a felony of the first degree with the MDO specification.
And what's the mandatory time for all that?
What is that for that?
11
years. So, I mean, we'll get off here. If you want to sit around here at this point, at least to talk with them, you can, you should. You should work with them. They're good lawyers, and they're here for your best interest, whether you believe it or not. If you want a few moments to speak with them, we'll leave and turn off everything. I'm happy to do that.
I would like that.
And Your Honor, in the defense of Mr., oh God, John and Ms. Novotny, if the court would like me to proffer why this all occurred, I will do that.
Why, what all occurred? I don't want you to do it. When you say why?
Where he wasn't responding to them and all that, there's other factors that go into that.
I don't think that's necessary.
Because I can't stand here and listen to him malign Mr. Patika and Ms. Novotny.
The obligation's on him just as much to reach out if he wants to talk with his lawyers. He chose not to do that at all. So we don't need to do that, but I appreciate that. But we're gonna get off. I'm gonna get off the bench. The prosecutor's gonna leave. We'll turn off the mics and everything, and you can. In fact, why don't you go in the? We'll let you go in the jury room. It's more private in there. There's gonna be a deputy in there, but we'll just stand off to the side, and you can talk with them.
Thank you.
All right. Anything else for the record?
Nothing more.
All right. Thank you.
Okie dokie. So he's going to buy a lawyer, or that's what he implied that he might to do. So I went out to Amazon. There is a definite gap in the market. I cannot find a lawyer for sale on Amazon, and Amazon sells everything. So I'm thinking, I want to do a bunch of new merch for 2026, and I'm thinking we need a lawyer you can buy. So I'm going to have to work on that because, the businessman in me sees a gap in the market. You have somebody like this that wants to go buy a lawyer, and it doesn't seem like you can get one off the shelf. So I'm going to see if there's something I can do about that. So stay tuned. Let's go to Texas, Judge Stevens.
Four cases? Or five?
Five.
Five. All right. Mr. Curtis, as you know, you're charged with serious offenses involving child pornography. There's a first-degree felony, which carries with it up to life imprisonment in 2459. Then there's a state jail felony, invasive visual recording in 460, which carries with it up to 2 years in the state jail. Then we have another state jail felony of invasive visual recording in 461. And an additional illegal possession of promotion of lewd visual material depicting children, a state jail felony in 2462, and finally in 2463, a second-degree felony of burglary of a habitation. So that carries with it up to 20 years in prison. So it's total, you're exposed to 26 years in prison plus life on all of these, adding them up together. All right, what are we going to do?
Judge, I know we're getting up there in age a little bit.
Yeah.
Miss
Yeah,
Moore
year.
recently
Yesterday, I think.
inherited these cases upon her return to the DA's office. Mr. Davis and I would like some time to speak with her before we formally put these
Sounds like-
profiles out there.
Yeah, 4 weeks. And that's it, right?
Yes, sir. Probably.
And okay, and we're gonna go to trial, it's gonna be the 2459, the first degree felony.
We know that's why
We'll take that
I'm
first.
asking before we get that.
All right, then we'll go one after another. Get a resetting.
Thank you.
Okay.
He's present.
Well, 557. That's another old one. This is another old one.
I know.
So.
Here, sorry.
What are we gonna do?
I suppose the court could put it on the trial docket, if that's necessary. I've got an issue in another county that's unrelated to this. Frankly, doesn't have much bearing on the outcome of this case at all, but
I think there's a deferred offer written down. I don't know what the status of that is, but it's not going to change right now. If you want to just have a little time to work on the other county for a minute. That way we don't have to place it on the trial docket, just give them 2 weeks.
this case will get resolved at a trial this month. I need the other county's issue to have an answer before.
Time wise, what do you ask?
6 weeks.
How much?
6 weeks.
I'm gonna do you 4.
Okay.
Okay, thanks. Armando Alvaro, is that a hearing?
Here, sir.
That's a hearing.
What about Andrew Barnett?
He's present, yeah.
It's all right there in the edge.
So,
Yeah, you're gonna have to unless you want to.
I don't.
I don't.
Right there. Yeah,
Trial
sorry.
docket petition.
okay.
We were waiting for me to find the complaint. I found him in Louisiana and he's wanting this prosecuted fully, so it's.
Okay, 3rd degree felony up to 10 years in prison.
Yes, sir.
Right?
Yes, Judge.
I'll get a lot of these.
Yes, sir.
This,
We've tried it.
sir.
We've tried several of them. So,
Okay, then it will be set for trial. And then Alvaro.
This one we already tried jury, gave him probation. I think he's asking for removal of something that was on the bond, but it's not on his probation order.
I filed. There's a misdemeanor DWI that was the companion case to the case that we tried in early October.
This is the case out of,
Yeah.
command.
Yes.
After we received probation from the jury.
Yes, Judge. After that happened, 2 or 3 weeks later, we resolved the misdemeanor DWI for time in the county jail. My belief is that once that judgment was entered, the bond conditions on the misdemeanor are extinguished. So as a condition of his bond on the misdemeanor DWI and at the interlock, he's had it in his truck for 4 years. My position is that the judgment is what should be sufficient to take to Smart Start or any other interlock company to say, I now can have this removed. He's not on probation. It's not a condition of his probation.
Why can't I?
You can, I suppose, as a condition of the felony probation. I obviously would ask the court not to. He's had it for.
Well, okay. What are we talking about now? We're talking about auto ignition interlock?
Yes. It was a condition of bond in the misdemeanor case.
Okay.
I filed a motion in county court to have it removed because Smart Start? Yes. Smart Start has found insufficient the judgment to take the interlock out of his truck. He is perfectly within the rules to have that removed. It's no longer a condition of his bond. He's not on bond.
Judge, I don't know if we have anything in this court to do with that on the misdemeanor DWI. That may be between the judge there.
Okay, he does. I got an order in August signed ordering him to have an auto ignition interlock system as a condition of community supervision in this case.
On what date, Judge?
On August 27th. Which would be normally customary in something like this. I normally do that. And that was in August. He hadn't been doing that?
He has been.
Yes.
Oh, okay.
They're trying to get it removed.
The interlock has been in his truck since December 20
Okay.
something of 2021.
Okay. For a different reason.
As a
This,
condition
the
of-
auto ignition interlock is here for this reason, because it's a condition of probation from the jury decision.
Which I overlooked this, otherwise I would have addressed it
Yeah,
differently.
But I signed, I can't remember actually doing that, but that would be normal and customary. That's what I do in this type of offense.
Wouldn't it be, Your Honor, more normal and customary in a case that's actually a DWI indictment and not? I know this was an alcohol-related case. I'm not pretending it wasn't. That's why we tried it. But it was an accident involving injury, not DWI.
It doesn't matter. It was part of the circumstances of the cause of the event.
Understand. Our position, I won't re-argue the bond thing. He's had it for 4 years. He's done well. I know the court and the state's position is probably, yeah, he's been in there for 4 years. I get that. But at some point, there must be some level of relief now that the case has been resolved. And I think that the jury's verdict, based on everything that they heard, carries some weight.
Of what? Of what as far as this condition is concerned? Why does it carry weight for my decision on a condition of probation, which involved a circumstance involving alcohol?
I think if the jury
That's what
believed that those two things were that related, we wouldn't be here. He would have gotten 10 years in prison.
I'm sorry. Well, number one, you bring some jurors up here and testify to that, number one. But number two, when it becomes my supervision, it's my domain, not theirs. But I don't remember them saying that or reflecting that. I remember this situation. But this, whenever there's an involvement of alcohol or drugs, then we do something to prevent someone from doing something a second time involving a 4,000-pound missile. Everybody has to act responsibly. Lives are dependent upon it. So I'm going to stand by right now that order, and it's going to stay that way. And what does it cost you?
Like $200 a month.
I'm sorry, sir?
$200 a month.
Where are you employed? How are you employed?
I'm self-employed.
Okay. And at the end of the day, this is what I'm going to conclude with, because I think this is what carries the day on this issue. Mr. Alvera, the consequences of this condition to you and the difficulty that you have to deal with it, and it's the inconvenience of it and the cost of it is far less than the family that lost their loved one forever because you fled while they died at the scene. That's what I balance. Can you understand?
Yes, sir.
It's not a close call. You can figure out how to bring them back to life. I'll drop this condition. I'll probably relieve you of this condition sooner than later. But right now, it hadn't been but a few months.
I don't mean to be argumentative, Judge, but it's.
What was my order?
This.
I'm talking about my order on this.
I understand.
Okay.
Want to be clear that he had it in his truck while the case.
I'm just talking about my order
Understood.
on this probation. Yeah. Okay, what else?
The misdemeanor case was resolved. The court will also recall that it ordered upfront jail time after the jury's verdict. Armando.
Was it 180 days, I guess? That's what. Stand by.
I think it was 180.
Yeah. Oh,
It was all of it.
Hold on.
College.
And here's the judgment on this. What's the 180 days jail time on that?
It's gonna be a separate. It'll be.
You copy this? It's not on there, Judge. That's just a interlock. That's yours. That came out of the court's file.
Oh, okay.
That's all I want to make sure it got back for.
Thank you.
That was assessed at sentencing?
Yes.
Have you been going to jail?
Yes.
I know I remember orally ordering that. I'm not seeing it on the written order. Which is more of a oral, it's a memorialization.
Right.
But the court made its order, but it's not in the written order.
But if it's dictated, the dictated order.
Yeah, I mean, I made it.
I know the court told him to go because I told him to go and I wouldn't.
Yeah, I know.
Otherwise.
I made the statement and it was an order. It was an oral order, but we normally memorialize those for posterity.
Yeah, I'm looking, Judge, I have the order where it shows that he could start weekends.
I think we waited a couple weeks after the verdict to get some affairs in order.
Yeah, I have the order where it said he could start weekend jail time.
Nonetheless, it was ordered.
Sure.
And it's somewhere in the 5,000 case load paperwork that we're having to deal with in this court.
Understood.
So go ahead. What do you?
I'm asking the court to suspend the remainder of that time. He's done it faithfully.
How many days has he been credited with, do you know?
He's done.
September 19th.
You're doing every weekend?
Yes, sir.
How many days are you getting credit? Is it 3?
My
You come in on Friday?
Yes, sir.
And then they release you on Sunday?
Yes, sir.
You should be getting 3.
Yes, sir.
He's done.
I thought each day, I thought when he shows up, they give him that credit for that day. And then the second day, and then the third day, even if it's partial, he gets 3 days.
That's correct.
They stopped it.
Yeah.
They only give them 2 now.
Did you know? Kendall?
Yeah, they did stop it, Judge.
They're just giving it per hour. You have to have 24 hours.
Yes, they're only doing 2 days now. Give them 2 days credit.
All right.
Which
I don't know how much. Well, do we know how to credit his jail time? We can do that. We can find out where the number is.
Yeah.
Did we find something?
It might be, I reprinted the file, Judge, but I didn't have time to go pull it from the vault. So it might be in an order that's not scanned in our in our file that's in the vault. I just, by the time we got out of court yesterday, I didn't have time to go pull it, so.
Because I've got the community supervision order. I've got
So I printed everything that was.
the supplemental order signed on the same day
Mhm.
of additional terms of probation, which is
But it just may be in an order that's not.
auto ignition, complete MRT, moral reclamation therapy, and complete defensive driving as directed. But there's no, but I know I orally ordered there it is, serve a term of 180 days in the county jail. It's in this order.
Okay.
Over the top.
Okay.
But if you can tell me how much credit, and I will say this, this isn't the timing of such a thing, such a request is not ripe for me at the Christmas holiday season. I'm not gonna stop that condition. Since this is the most vulnerable time for people on the roadway. This is where most deaths occur during the holiday season. And
Has he been doing weekends, Paul?
Yes.
and
Cause it.
so I can revisit this at another time, but not now. I'm not gonna grant it right now.
They're not showing it?
Well, it doesn't show that he ever booked out.
He's right here. He's right here.
I know, but that's what I'm saying. I'll have to call and tell him.
Following for escape.
See, that's how they do it now. They don't do it, they don't book them out until actually the last day. But if you look at the screen that shows the something screen, it'll show like the exact days.
Well, does it have a running total? That's what we're looking for. Where's the data that shows a running total?
Well,
What's
What?
his time?
You're showing it's still totaling today, too.
Yeah.
Section.
One more issue, Judge, from the court.
Which question?
Because when I go to jailings, it's 91, which is not accurate.
These phones, intern. But they have broken up in increments.
Okay, so
Is it at the top?
It should be at the very top.
he started in August.
Are you gonna do?
Yes. Or September.
I mean-
Right, because August was the judgment.
Same thing we. Sure.
Yeah, what's it called?
See, this would all been afforded that you're down.
September, October, November.
But that is,
Got what I asked for, more issues.
see, my one is so simple enough.
I don't think I have
Done it
permissions
three.
for that.
Okay. So the thing.
I still have this stuff.
I mean, he can't have 30 to 40 days if he's only doing 2 days.
That's story. Okay.
He's only credited to 2 days.
I know.
He can only, he's only got 30 or 40 days credit.
Yeah, I don't have permissions for whatever screen breaks it down, Judge. I'll have to if I get permissions for that. So I don't have an accurate.
During this time, at this time for the circumstances of this case, I'm not granting the relief right now.
Would the court consider modifying his weekend curfew or his ability to operate a motor vehicle on the weekend in lieu of fully suspending jail time? It's about to be crawfish season. He's about to move to working 8 days a week. And the weekend time.
Okay.
Is valuable.
What is the?
What?
Okay, I have be inside your home 10 p.m. to 6 a.m. That's the only curfew.
I'm sorry.
It says be inside your home every day, 10 p.m. to 6 a.m. That's the only curfew. What else is there? What do you? I don't see anything.
Have to wait to get some relief. That's
Well,
all of it.
What are you asking for? Because I'm not keeping him in home except during for curfew. I mean, he can out and about as long as he has an auto ignition.
And with curfew, usually they'll allow you to work if you're working, isn't it true probation allow you to work if you've got a curfew, if you work past that curfew, as long as you let them know?
The reason that I'm asking is because the weekend jail time is going to affect his ability to work. That's why I'm asking for the
Well,
relief.
okay, but I'm sorry, but he's gonna continue to do weekend jail time for the reasons I stated. There was a fatality and a death. And that may infringe upon his work opportunities, but it's pale in comparison to what happened here and the loss of life. What's the value of that? There is no value to it. It has no quantifiable because it's forever. And the loss of life is the most precious thing that we have.
Okay.
When we lose it,
Yeah.
there isn't anything that is close to value that compares to it. You have your life. You've got some conditions which may be difficult or inconvenient, but you've got a life to share and enjoy with your family and friends. This deceased person doesn't, and their family was lost. And at this time of the year, I'm sure they think, well, that's what people think about. It's their loved ones here and gone. So no, I'm not going to grant the relief at this time for this situation.
We can certainly reserve our right to revisit it later. Yep. Okay.
Okay. You may. Yes, sir. All right. Who else was this? Is that it?
Yes.
Okay, that is Andrew Barnett. We put that on the file.
All right, let's change things up. Let's go over to Florida and see what's going on with Brantley Clark.
Judge, before you is Renee Lundy, and she's here in case number 252375. We have reached a plea agreement, and she's also here to plea in case number 25MM3477. In the felony case, she will plead no contest to one count of accessory after the fact to escape. Adjudication will be withheld. She will be on probation for 36 months, court costs and fines at standard rate. Restitution in the amount of $200 to Tivon Beaton, 100 hours of public service work, $20 monthly supervision. She will submit a DNA sample, forfeit any seized items, and stipulates to the fact for purpose of the plea. She understands that there's a minimum cost of prosecution and no contact with any victims or co-defendants.
The one change there's no restitution. That's not accurate.
Okay. So there will be no restitution. And how old are you today? 28. And what's your highest level of education? And in case number 25MM3477, I am not the attorney of record. She is self-represented, but I offer to stay in for purpose of the plea. And
you just hand it up. Just do it in a extension.
That's all I have then.
Raise your right hand.
It just means that we're doing it as we're doing it.
Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
What was she charged in the misdemeanor?
The misdemeanor, oh, I'm sorry, I probably didn't put that on there. Offer to commit prostitution.
Oh. Ms. Lundy, state your name. She's been sworn.
Cornell Lundy.
Ms. Lundy, you just heard the announcement of Ms. Bennett. Is that correct?
Yes.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter the agreement or understand any of its terms and conditions?
No, sir.
I've been handed a plea waiver and consent form. Here's the front page. On the second page is a signature of his defendant line. Is that yours?
Yes.
Have you had a chance to read that agreement?
Yes.
Have you had a chance to go over your case with Ms. Bennett?
Yes.
Have you had sufficient time to speak with Ms. Bennett about your case?
Yes,
Are
sir.
you satisfied with your lawyer's advice and counsel?
Yes, sir.
You understand that by entering the plea, you're waiving your right to go to trial?
Yes, sir.
You're waiving your right to require the state to prove the allegations against you?
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses to the allegations you might have.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which would be your decision to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
You're doing your own free will.
Yes.
Ms. Lundy, do you feel this plea is in your best interest?
Yes, sir.
You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea.
Yes, sir.
And Ms. Bennett, do you stipulate?
Yes, for purpose of the plea.
I'll accept the stipulation. Finders of prima facie case find that Ms. Lundy's plea was freely and voluntarily made after consultation with her attorney. I'm going to accept it. Adjudication of guilt is withheld as to the accessory after the fact to escape. She's placed on a term of probation not to exceed 36 months. She's ordered to pay fines and costs of $1,028. There's no restitution applicable in the case. She must complete 100 hours of community service work at a minimum of 8 hours a month through the Bay County Work Program. I'll give the Florida Department of Corrections the discretion to amend that to at the direction of a probation officer. If she's required to give a DNA sample, she must submit one, forfeit any seized items, no contact with any victims or co-defendants. Ms. Lundy, you have 30 days to file your notice of appeal if you wish to appeal your judgment sentence. If you'd like to have an attorney to represent you, you can. A 411 may be appointed to represent you at no charge. And if I fail to say if she forfeit any seized items. Good luck to you. You need to step over and speak to the probation officer.
Thank you.
Next, I have Mr. Brunier. And Mr. Brunier is here on two cases, 23-1957 and 23-4020. In his case, we also have reached a plea agreement. He will plead no contest to a reduced charge of felony battery in case number 23-1957. He will be placed 5 years DOC in that case. In case number 23-4020, he will be placed on 5 years probation following his DOC sentence. And court costs and fines are at the regular rate. He is entitled to 934 days of jail credit in case number 23-1957 and 781 days in case number 23-4020. He will be adjudicated guilty and time served on the misdemeanors. He will submit a DNA sample. We stipulate for purpose of the plea. He understands the cost of prosecution, forfeit any seized items, no contact with any of the victims. The Florida Department of Motor Vehicles may impose additional sanctions. They may suspend your driver's license for 6 months. 100 hours of public service work. During probation, $20 monthly cost of supervision, and he will go through a drug and alcohol evaluation and counseling as recommended, and shall be subjected to random UAs, and that is the extent of the agreement.
And all the other counts, 6, 23, 40, 20 are consolidated.
That's the agreement with the state?
Sometimes it this way, sometimes that way.
Find a seat, please. Take your hood off your head.
Okay.
That's fine.
Raise your right hand. Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
All right, sir, you can lower your hand and state your name.
Tyler Bernier.
Renee, you heard the announcement of Ms. Bennett, is that correct?
Yes, ma'am.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter the agreement or understand any of the terms and conditions of it?
No, sir.
I've been handed a plea waiver and consent form. There's the front page. On the second page is a signature over the defendant line. Is that yours?
Yes, sir.
Have you had an opportunity to read that agreement?
Yes, sir.
Have you had an opportunity to go over your cases with Ms. Bennett?
Yes, sir.
Have you had sufficient time to speak with Ms. Bennett about your cases?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
You understand that being under the plea, you're waiving your right to go to trial.
Yes, sir.
You're waiving your right to require the state prove the allegations against you.
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses that you might have to the allegations.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which would be your decision to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Renee, you feel this pleas in your best interest?
Yes, sir.
You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
Yes, sir.
Prima facie case on the felonies, please.
Your Honor, the state is ready to prove in case number 23-1957 that the defendant Tyler Barnier between May 1st and May 21st of 2023 did unlawfully engage in sexual activity with SBM, a person 12 years of age or older, or less than 16 years of age.
All right. And then accept the stipulation on the possession of a controlled substance. See, I'm going to find there's a prima facie case. I'm going to find Mr. Bernay's plea was freely and voluntarily made after consultation with his attorney. I'm going to accept it. He's adjudicated guilty in 23 CF 1957 of felony battery, and in case number 23 CF 4020, he's adjudicated guilty of possession of a controlled substance, possession of paraphernalia, and resisting an officer without violence. On the felony battery, he is sentenced to 5 years in the Florida Department of Corrections, given credit for 934 days time served. On the possession of a controlled substance, he is placed on a term of probation not to exceed 60 months to run consecutive to the sentence received in case number 234020. He's ordered to pay fines and costs of $1,303. Those include discretionary costs of $2 of local law enforcement education, a $65 assessment of additional court cost, a $700 discretionary fine. There's no restitution applicable, and that's either case. Is that correct, Mr. Ferrer?
Yes.
Okay. He's required to give a DNA sample. He must submit one. The forfeit any seized items, no contact with any victims. Florida Department of Highway Safety Motor Vehicles may apply additional penalties. You'll be required to do 100 hours of community service work at a minimum of 8 hours a month through the Bay County Work Program. I'll give the Florida Department of Corrections the discretion to amend that at the direction of probation officer. His cost of supervision will be $20 a month. He must undergo a drug and alcohol evaluation, follow all recommended counseling. Zero tolerance for use of any controlled substance not prescribed by a treating physician. On the possession of paraphernalia and resisting officer without violence, he is given credit. I mean, he's sentenced to the time he served in the Bay County Jail, given credit for that time. Those sentences will run concurrent with each other and concurrent with the sentence received in count in the sentence received in the felony battery. No, they're just excellent. He's given the credit for that, and that's over with. The state has consolidated the other counts that weren't taken care of. Have I left off anything?
I'd just like to put on the record that this was done in line with the victim's wishes. That was a conversation that occurred back in June of this.
Okay. All right, sir, you have 30 days to file your notice of appeal. If you wish to appeal the judgment sentence, if you'd like to have an attorney to represent you, and you can't afford one may be appointed to represent you at no charge. Good luck to you. You need to step over and be fingerprinted.
Next, I have Christopher Coatney. Mr. Coatney. And in Christopher's case, we had depositions on the 8th of the co-defendant, and it turned out that there's also an expert involved. The state has recently disclosed said expert, and we have set that person for depositions on January the 15th.
Is that a new expert?
Yes, sir.
Judge, so this expert was actually disclosed by the co-defendant.
During the depositions?
No, I got it the week before the deposition. So the co-defendant Samantha Hewitt, Mr. Stone.
I'm well aware.
Is essentially her defense for her case was that she was battered by Mr. Coatney. They hired a battered spouse syndrome expert, and I'm using that expert to explain why she's given if statements throughout the process, essentially.
All right, when's the
So
that's
why I just got it.
When's the deposition set?
January 15th.
All right, let's set this for January 22nd and see where we're at, okay?
I will be out of town.
February,
Judge, can we maybe set that February trial management? Because that should give us enough time to get that depot done, and then we need to get a trial.
all right, we'll set it for February 19th at 8:30 for at 9 o'clock for a trial management. You want to set it for March?
March or April, either one.
All right, let's set it for April, that's 7th,
April 6th is trial.
April 6th at 8:30 for trial.
Next, I have Bianca Jordan. Ms. Jordan is here in case number 251849, and she has applied for a Nelson hearing. And so I believe we can address that.
All right. Ms. Jordan, what relief are you asking for today?
I want to know, can I get pretrial release?
I'm gonna deny that or tennis motion for pretrial release. What else are you asking for?
Well, I want to know what's going on with my case. I've been in the county for 5 months.
What are you asking for this morning, though? That's what I'm asking.
This is about your motion for different counsel.
Yeah, I want to know what's going on with my case. That's
Okay,
why I
please swear
filed for a
Ms.
motion
swear
for
Ms. Jordan in.
counsel. Also, I want to
Hold
know.
on, I'm gonna have you sworn in.
Okay.
Promise for the testimony you're about to give the truth, whole truth, and nothing but the truth, so help you God.
Yes,
All right, ma'am, state your name.
Bianca Jordan.
All right, what are you asking? I can't tell you anything about your case because I don't know anything, not one thing about your case. But tell me what you want this morning.
Well, I want my counsel to come see me to tell me about my case. I'm having all these different charges and it's not adding up to like while I'm in here. I'm being charged for a fish violation. I don't know how to fish. All this other stuff being added towards my charges. Like, I don't understand what's really going on with my case.
What do you want me to do?
You the judge. I need you to have some kind of input on my case.
No, ma'am, that's not my position. Tell me what you want me to do this morning.
Well, I want to represent myself.
All right, well, state your name. I've already
Bianca-
stated, I know your name.
Bianca.
All right, how far did you get in school?
I graduated high school and I have college education.
So you can read and write.
Yes.
Okay. What do you do for a living?
I have 2 businesses. I have a hair business and I have a pressure washer business.
Okay.
Also, I cook. I do a lot.
Have you ever represented yourself before?
No.
Do you have any legal training?
Yes.
Okay. And do you understand that attorneys are trained in the rules of evidence, criminal procedure, and the law? They're there to assist you in preparing for pretrial motions and preparing for trial and regular court dates. You understand that?
Yes.
You understand if you represent yourself, you'll be held to that same standard, that no one can give you any assistance. I can't have any input in your case.
Yes, but I plan on hiring a private criminal lawyer.
All right. Well, do you want to represent yourself or do you want to hire a lawyer?
I'm gonna do both until I get out, post bond and get out and pay for my.
I think is she being held without bond?
No, sir, we had actually for the record, we did have, she was held without bond. We had a bond hearing. Her bond was reinstated. We had 2 depositions set and conducted. There's more depositions needed. One was a minor that was supposed to be served by the state and that didn't happen. So that is essentially where we're at.
Okay. Are you still want to represent yourself?
Yes.
You should understand that you'll be held to that same standard as a lawyer. I can't give you any assistance, and the assistant state attorney can't give you any assistance.
Okay.
You still want to represent yourself?
Yes.
Okay, I'll find that you're competent to represent yourself. Ms. Bennett, I'm gonna ask you to stay as backup counsel. She's just backup. If you ever ask for an attorney, Ms. Bennett will be reappointed to represent you. You don't haven't hired one. All right, so what do we need to do?
And there is one, we conducted a deposition. We still have another deposition to reset. I know there's a co-defendant that Mr. Meredith represents, so both cases are kind of moving in tandem.
You're gonna have a hard.
I don't think those depositions have been rescheduled yet.
You're gonna have a hard time deposing anybody in custody. You understand that? But that's up to you if you want to represent yourself.
Well, nobody, none of my witness is in custody.
All All right.
And one of my witnesses wrote a statement, so I don't know why that's not standing.
Okay, all right. We just need it set up for another pretrial. Or the deposition's been set, Mr. Meredith?
No, sir.
I will set this for January 22nd at 9 o'clock. You're representing yourself now. Good luck.
Okay.
And I will not be present at that court date.
That'll be fine. You're just back up. All right, ma'am, if you have a seat.
Good luck with that. How does it go? If you represent yourself, you have a fool for a client. Okie dokie. Let's go back up to Michigan. We'll check back in with Judge Simpson.
This case of the people versus Ariana Fenn.
Wow. Kenneth Overwater, Assistant Prosecuting Attorney for the People. Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Ms. Fenn, who should be on Zoom.
I'm right here.
Okay, state your name, please, ma'am.
Ariana Van.
All right. Your Honor, I would ask if the court could pass this matter for just a brief bit. I believe Mr. Overwater and I were working on a plea arrangement that'll resolve the matter off the court's docket. I can prepare a plea.
And that wasn't done.
We were working on it this morning, Your Honor, and ran out of time. I do apologize.
Pass it.
Thank you. Thank you, Your Honor.
Court calls case people versus Amari Harris.
Overwater, Assistant Prosecuting Attorney for the People.
Morning, Your Honor, with Barnwell, P42505, on behalf of Mr. Amari Harris.
Your name? Amari Harris. Thank you. What are we doing?
Your Honor, I'm setting it for a preliminary examination. I already have both electronic and paper discovery.
All right, that's on both cases. Ms. Barnwell.
You know
Let's
what?
vote.
I represent him on the armed robbery.
You're ready. It is the public, Ms. White.
I think Mr. is right to go there.
And while we await,
What's your name?
Barnwell, is there a co-defendant on your case?
Yes, I believe so.
There is, Your Honor. It's Mr. Kilowog's client, Ms. Cruz Menu. Although I believe different counsels coming in on that today.
My understanding, Judge, Mike Gaddy from the PD's office, Judge, my understanding we conflicted off of off of both matters. Is that right?
I'm sorry?
Both cases involve the same people, Your Honor. If there's a conflict on one, I would suspect there's a conflict in the public.
But I don't have anything that has conflicted them off. Why is that?
You're talking about the armed robbery. That was presented to you.
I know, but
Okay.
they're telling me that this also, there's a conflict.
Yeah, I just earned up that one today.
Yes, the file notes say, Judge, that Ms. Barnwell was appointed on both.
Oh. We have an adjournment so that so that we can make sure you have all the paperwork.
I have nothing that says that.
Put down an adjournment and I'll go speak with Ms.
Well, she's asked on the one case, two things here. She's asked on the one case for it to be set for exam. She wants it set for exam, it's fine, but now she's on the other case and I don't know to what extent that dovetails into it. I also have a co-defendant. Mr. Kilowald, is that Mr. Kilowald?
Judge, there's another attorney here who I found out last night is hired. They're going to substitute.
Oh, this is just a bundle of joy. Everybody approach.
Yeah, because people are shaking their head and I don't know what they're shaking their head about.
I bet it.
Okay, well, he's muted. A couple of programming notes. We are going to try to do a third hour today and get back on track with that. As well, tonight, sidebar, 8 p.m. Eastern, 5 p.m. Pacific. We're going to do a little bit of a year in review tonight, where we'll talk about some of the bigger cases that we've seen here on TCF over the past year. So we'll get into that and see where that discussion goes. Also, tune in tomorrow for tomorrow morning's live show. We're going to, at some point during it, talk a little bit about the direction this channel is going to take in 2026, because I'm going to make some changes. It's going to be a little different. So be sure to join us for that. All right, we'll hang here for a couple more minutes. If he stays muted for too long, we'll move to another court, but we'll give him a minute. All right, I don't get the impression that he's going to unmute anytime soon. Let's go to Judge Middleton.
Good morning. I'm Judge Middleton. I think we met by Zoom. I don't remember. Were we actually in here?
We met by Zoom, sir.
By Zoom. Well,
Yes.
Meeting you in person here today. You're Daniel James Gavin.
Yes, sir.
This gentleman is Mr. Tyrone Fleeman. He is a law partner to your lawyer, Casey Strong. He's been practicing law for 25 years or more, and she's unable to be here, and she has prepared him for the case. I understand he's come and met with you this morning. Is that acceptable to you that Mr. Fleeman appears on your behalf?
Yes, Your Honor.
All right, thank you. Prosecutor, do you have any objection to that?
No, Your Honor.
All right. All right, Mr. Fleeman, what would you like me to know?
Your Honor, only that I think we are in agreement with the recommendation made from the victim impact panel that I know that Mr. Gavin has served the 30+ days at this point, and they're asking for a mental health assessment to ensure proper diagnosis and treatment, intensive outpatient rehab, no recreational drugs with routine mandatory drug screens, mandatory individual therapy, anger management, appropriate punitive damages as deemed by the court. I would hope that would be the 30 days she's already served, and then probation with optional residence at community probation to ensure successful integration back into the community. And I don't know if that's necessarily the best place to go here, but I have spoken with Mr. Gavin about the fact that he needs to find a place to go, that he is not welcome to go back to the house. He has to find another place to go. And also, I forgot to mention that at some point you will need to schedule a civil standby with the police to go get stuff out of the house. You don't want to just go there without police going with you. Okay. And Your Honor, I'd ask that you follow the recommendation.
What recommendation are you referring to?
It's actually something that came from the victim themselves, and it was an email sent to Miss Ackerman, Kendra Ackerman. I don't know who that is.
She's kind of famous around here, but let's see if we can. I'm not.
And I'm reading from an email that went from Linda Gavin to Kendra Ackerman.
I don't believe I have that.
Oh. I guess I thought you would already have that. Would you like a copy?
No, I don't have it, but I'm certainly willing to look at it.
And from what I can tell, Your Honor, it looks like Mrs. Gavin prepared that herself. I don't see any other name on that. I don't know if she had help writing it.
Okay, thank you. Do you have it, Ms. Canfield?
Oh, Your Honor, which is, I'm just speaking with Ms. Ackerman about it. It typically goes right into our file through scanning and let me see.
So I was not crazy to think that you would
Let
have.
me correct myself. Let's see. I do have it, Your Honor.
Okay.
My apologies. I did receive that. And I would like to also point out that Ms. Gavin is present, would like to address.
Yes, I'm happy to be able to hear from her. This is a dynamic that we have often where there's a domestic assault and the assault is between the child and the parent. I don't know, we may have 20 of these a year. And this is sort of failure to launch syndrome. The defendant's 27, still living in his home. His contention was his mother told him he was a worthless piece of crap and he just sort of lost it. He indicated he was a chronic marijuana user, but marijuana is lawful for recreational purposes for adults. He's either unemployed or underemployed and really needs to launch himself. So let's hear from Miss Gavin first. I just now saw this. Would you come up and have a seat?
I got to step out of the studio for just a couple of minutes. I'm going to leave you with Judge Middleton and I'll be back.
You're Linda Gavin
Yes, Your Honor.
and you're Daniel's mother.
I am.
What would you like me to know?
I have prepared a victim statement that I would like to just read to you.
Yes.
As mentioned, I am the victim of the alleged assault involving the defendant on 11/22. I'm submitting this statement to offer perspective, to illustrate its effect on me, and outline what I believe to be appropriate sentencing recommendations. But first, I would also like to say that I was initially not directly contacted by the prosecutor's office, specifically by phone, before the pre-exam conference on 12/9, even though I had reached out to their office on 12/4. On that same day, I also left a voicemail for the victim advocate, which I did receive a return call on Monday, December 8th. I'm highlighting this concern because I want to be certain that my rights were adhered to according to the Crime Victim Rights Act. And therefore, I'm here today to ensure that my voice is heard. The events leading to the incident on that day are relevant because it gives insight into his ongoing mental health challenges and current mental status on that day. At the end of September, he was terminated by his employer. And over the course of the next several weeks—
Who was the employer?
Peterson Spring Corporation.
Okay.
Over the course of the next several weeks were episodes of increasing explosive behavior, an episode of indecent exposure, and many episodes when his anger was disproportionate to the situation. He participated in online fights with people on Facebook who found his comments so disturbing that 2 individuals contacted non-emergency dispatch phone number. I was contacted on 10/4 at 12:29 a.m. to answer a call from an officer doing a welfare check. We also learned that during that time, he stole money from us to purchase marijuana. The day of the alleged assault, I was involved in a heated discussion with the defendant regarding ongoing issues of household expectations, pervasive lack of respect, marijuana use, unemployment, and improper use of social media. I was told, among other things, "You're a loser, you're worthless, you're a piece of shit." In exasperation, I echoed those words right back to him to hopefully demonstrate a "how do you like it" moment. And unfortunately, it was at that moment I was struck on the left side of my head with a 24-ounce tumbler. I fell into the bed, covering my head with both hands, and felt 4 or 5 additional blows with that same tumbler. I got up and attempted to flee, but I was chased into the next room and was pushed or tackled under the end of the couch, where I suffered repeated blows with his fist on my arms and back. I pleaded with him to stop, which he did, but then took my phone and locked himself in the bathroom. I repeatedly knocked on the door begging for my phone. He questioned as to why I wanted it, which I replied that I needed to contact his dad. I wasn't feeling well and needed help. He finally gave me my phone, and I proceeded upstairs to my bedroom and immediately placed a call to 911. During the call, the defendant entered my bedroom, motioning with his hands to stop and could we work things out. I simply shook my head, to which he began walking toward me. I told him more than once to back up. As he lunged forward, I believe I stated, "Somebody please help me," before he grabbed my phone and fled the house on foot. After my phone was returned, I discovered both the location and the phone were turned off. This has affected both my physical and emotional health. I have a confirmed closed head injury with concussion and persistent symptoms of increased headaches, initial episodes of dizziness and tenderness at the pain at the injury site, large bruises on my left arm, small bruises on my back and posterior right arm, and right hand swelling and bruising. My emotional health has been significantly impacted with increased episodes of anxiety and persistent depression, along with symptoms that may be consistent with PTSD, such as flashbacks and nightmares. As a mother, my heart is devastated. And as a victim, I am pleading with the court to consider all options of rehabilitation for this individual. I am not seeking restitution or compensation. You see, this is his second domestic violence charge. The first charge occurred in 2022 when he assaulted his father. His employment history has been problematic, with a history of explosive outbursts, including 1 or 2 episodes requiring assistance with law enforcement after an altercation with a colleague several years ago. He has an extensive history of ADHD, ODD, learning disabilities with suspected bipolar or schizoaffective disorder, and autism spectrum. No formal testing has been done since elementary school age. He was a previous patient with Pivotal and recently established care. Our family was in process of seeking reassessment when this incident occurred. He has a history of chronic drug use and previous alcohol abuse. And in short, his mental health issues and substance abuse history have significantly affected his everyday life. Given his prior history of domestic violence and the severity of this incident, I would recommend the following: mental health assessment to ensure proper diagnosis and treatment program or regimen, intensive outpatient drug rehab, no recreational drugs with routine mandatory drug screens to ensure compliance, mandated individual therapy, mandated anger management course, appropriate punitive damages as deemed by the court, probation with optional residence at the community probation center. Furthermore, at the time of this incident, the defendant was a resident in our home. I'm requesting direction in proceeding with appropriate eviction measures, given his violent history and the fact that we are also in care of his younger disabled sister. Additionally, his father has significant health issues, including stage 4 kidney failure. All these factors, I believe, are reasonable in supporting our decision that we are no longer able to support the defendant, which includes residing in our home. I share this information with you as to not a point of blame, but to emphasize the seriousness of his issues and our concern for his future. His father and I love our son very much, but we are simply at a loss as to how we can help. So, Your Honor, please help us, help our son, so that he does not hurt someone else in the future. Thank you for your time and consideration.
Thank you. That was very eloquent. The police report indicated that they did call the ambulance service out to the house after you got hit in the head. I don't believe there was any blood. Linda was seen by 3 Rivers Ambulance, but did not go to the hospital.
No,
She
I
had
was,
several small lacerations on the left side of her head and a bruise on her arm. When did you get diagnosed with a concussion?
um, November 28th, I was evaluated at Three Rivers Health. I went there after work, because I work for Beacon. And so I was having increased headaches and other concerning symptoms that were consistent with a possible concussion. And so I was evaluated at the ER.
I think if the prosecutor had known these things that you shared now at the time they took the plea, maybe we'd be in a different posture here, but I didn't know it either. But the question still remains, this is a problem with not a simple solution. He didn't wake up one day with all of these problems. I'm sure he had a very difficult time in high school. I'm sure he had a treatment plan, and all through elementary and middle school and high school, people that are on the autism spectrum often struggle getting through high school. There is a phenomenon that occurs, and I wasn't sure whether we're dealing with this or not, when young men in their 20s develop schizophrenia. They're living their lives, they're playing sports, they've got friends, and all of a sudden, schizophrenia touches you on the shoulder. There was a young man here in our county who was president of his class. He was a star athlete, all-state athlete, went to college, went to Boston University Law School and got a law degree. And just about that time, schizophrenia touched him on the shoulder and his life disassembled. He also assaulted his parents. He did pass the bar examination and was ultimately sort of admitted to the bar after a character and fitness hearing. And then he never was able to practice law. He never was to flourish. He's passed away since. And I've seen it hits men more often than women, at least in my experience. So what you're proposing now makes him homeless with zero support system. You guys have gotten to the end of your rope. He's 27. Has he ever lived independently?
He's 31, sir.
31. Has he ever lived independently?
No, he is not.
And so through all of these things, it came down to this. There was an earlier assaultive incident than this one. And I don't disagree, and I understand why you don't want him back in the house, but some of these things are difficult to put together. They're also very expensive.
Sure.
Your suggestion of Twin County Community Probation Center isn't a bad suggestion. It's a wonderful program. We're lucky to have it. It provides structure and housing, but he's a misdemeanant. And you have to be a felon to be eligible to go into that program. So I don't have the authority to put him in there. I'm a big fan of our Twin County Community Probation Center, have been since it started 45 years ago. Ms. Campfield, her suggestions are all about right on the mark. Do you have anything else you wish to add?
Your Honor, I think that those recommendations to the court are more than appropriate, particularly given the extensive history that she's indicated was the precursor to this incident and the severity of this incident. This is something where it wasn't just fist blows. She was struck with a metal tumbler in the head and is still suffering because of that. Do you know how much credit he has, Your Honor?
26 days.
I'd recommend a 90-day jail sentence with credit for 26, and then follow that with at least a 24-month probation.
Then I only have 3 days worth of leverage left. It's a 93-day misdemeanor.
Oh, that's correct. No. Oh, did he plead to a first or a second?
He pled to a
Pled
first. No, perhaps you're right.
I think he pled to a second offense, Your Honor.
He did plead to a second offense.
Mhm.
All right. That gives me 365 days.
So I would like to see the remainder of that time held over his head for mental health treatment compliance and no new assaultive offenses or behavior during the term of probation or any other violations, in order to take medication as prescribed, to not utilize alcohol or drugs that are illicit, to test upon demand. And I think it's absolutely appropriate that he have individual and group therapy, and that should include a domestic violence intervention treatment.
Well,
that should be completed successfully.
that's a lot to pile on here. That's also expensive. But, all right, I haven't heard, so we're gonna try to fashion a plan for you, Mr. Gavin. You did accept responsibility for this. You told me that you hit your mother in the head with a tumbler. You actually gave her a concussion. You have a feeling of worthlessness and inadequacy. Your mother and father are frustrated. You're 31 years old. The current plan would be for you to live in your parents' basement for the rest of your life. And that's not that great of a plan. But I can't just dump you out on the front steps of the jail and make you homeless and penniless. I need to put together some sort of a plan, and I'm gonna need help. I don't have a magic wand and have an expensive, intensive outpatient drug rehab program. I don't know what your drug is. We don't have extensive outpatient rehab for marijuana use. We have people that have opioid dependencies and methamphetamine, and both are very difficult to deal with. Have you dabbled with methamphetamine
No, sir. No, Your Honor.
or opioids?
A little bit, Your Honor, in the past.
What kind?
Xanax, Percocet, sir.
All right, Percocets might qualify. And so they don't have an intensive marijuana treatment protocol. Alcohol is also in there. But we do need a number of things. We do need a mental health assessment to ensure a proper diagnosis and treatment regimen. I think you did the anger management course the first time. That class cost $680. The full domestic violence course. There's a probation oversight fee of $40 a month. There's fines, costs, attorney fees. You don't have any money. You're not unemployable. You've had employment, but because of your mental health situation, it's difficult for you to maintain regular employment. I don't encourage looking for disability at this point. I'd like you to have some sort of a life, friends, associates, things to do. But you've never lived on your own. And you're gonna have to start. This is a 1-year misdemeanor, not a 93-day misdemeanor. I didn't give you a chance to say anything. Is there anything you'd like to tell me?
Yes, sir. I just wanted to reinstate the fact that I agree on everything that's been stated about my mental health and receiving treatment. And I also wanted to reflect back on the fact of the housing, that situation. My father has told me that he knows well, we have a friend of the family, sir, and he knows someone who runs like basically a halfway house for people like me to get kind of their life back together. It's private practice. And then also Lauren from Pivotal at the jail, she told me something about free housing.
Well, I contacted Lauren after I talked to you the first time. Lauren is our mental health liaison, and she's doing just a wonderful job. We had some good service, then we had some gaps, and she's doing a great job. So I asked her to meet with you to help me with what we're going to try to do here. So good. She can help me find a treatment program. She may be able to help me find a residential program that'll help you take one step at a time. But I'm not just going to let you out of jail to stand on the front steps with 2 cents in your pocket and no socks. So you're going to be in jail for a while longer, which probably includes Christmas in the St. Joe County Jail. I am going to order 90 days jail credit 26. I can amend it. That leaves 54 days to serve. I can amend it up or down because I'm putting in a probation for 24 months. The fine is rights fee, a $50 state minimum fee, $150 attorney fee, and a $960 probation oversight fee. Now, the clock is ticking here. That's not right. 26 and 54.
64, Judge.
64 days. Thank you. We often have to add things up in landlord tenant. I use a calculator, but 64 days. You get 5 days a month good time. So 90 days is 75 days. So I want enough time to try to figure out some placement options for you. Let's add that money up. $1,235. Payment due in 1 year. No drugs and no alcohol, and test as directed. Now, as I said, it's legal for adults to smoke marijuana in Michigan for any purpose they want. They can't do it in certain places, but they can, just like you can order a cocktail, you can smoke marijuana, except when you're on probation. You can't drink any alcohol and you can't use any marijuana or any other drugs unless they're prescribed by a doctor. Have you ever been on medication for your mental health?
Yes, sir.
What kind of stuff were you taking?
Medication for my depression and anxiety, sir.
All right. When were you last connected to Pivotal?
About a month before I came in.
All right. Well, that's positive. Cooperate with Pivotal and follow recommendations. Sign a release. Let's say they find a place for you to go, an inpatient program that helps young men get on their feet. I can amend the probation and let you out of jail sooner than 64 days. But this isn't going to be something that they're going to snap their fingers and they'll have a place to put you. But we're going to look for something like that. Because you need to start somewhere to help you get your feet on the ground. They've got the Twin County Probation Center would be a great place. They give you a place to live, they'd help you find a job, they'd help you find alternative housing, like some of these places you're talking about, to transition from the probation center to one of these shared housing places with a job. Do you have a driver's license?
Yes, Your Honor.
All right. Do you have a car?
Yes, Your Honor. It's not in function right now, but yes, I have a car.
All right. Well, that's a plus. All right. Your mother is seeking intensive outpatient drug rehab. I'm not sure about that. I do agree, no recreational drugs with routine mandatory drug screens. We're probably also going to pursue individual therapy, but we need a mental health assessment to assure proper diagnosis and treatment. That starts right at the top. So let's figure out what services you need and then see if we can find a source for them. But in the meantime, you're going to stay in jail. The probation department's going to come out to the jail and see you or contact you by Zoom. I was hopeful when I talked to you at the time of your plea. You accepted responsibility. You've been very receptive here today. That had to be hard to hear your mother sit there and read that stuff. You want to be a better son, and they want a better son. But you get what you get. You didn't ask to have a spot on the autism spectrum. You didn't ask to have a mental illness, but this developed over your entire adult life. You've been living in your parents' basement since you were 18, and it's developed into this toxic relationship. And it's going to have to start by you living somewhere else. They're still going to be your parents. It's going to be an unhappy Christmas, but at some point, there's going to be some sort of reconciliation, and maybe you can be more successful in your life. I don't know. Anyway, you can go with the court officers. I'll notify the probation department, and we'll stay in contact with Lauren Frank and see if we can find some of the things you're looking for. All right, thank you for being here. It was very helpful.
Thank you.
Judge, that 1235, did that include the probation oversight, or was that just the first block?
125, 150, and the probation oversight of 960. So that can actually be cut.
1235 did include it. Okay.
Yes.
Gotcha. Thank you.
I think I might have left something out. 960 plus 150 plus 125 is 1235.
No, that sounds right. Yeah.
Thank you, Mr. Fleeman, for coming and covering for this.
Thank you,
It
Judge.
would have been hard to reschedule this, and I appreciate it. I understand we have Ms. Strong back this afternoon.
You do, yes, and she'll deal with that other matter that I think the court reached out to her.
Yeah, we got an extra case, and
she politely told me I was not qualified. So
well, it's a difficult case, and to do it on the fly, you're not qualified, but
certainly not prepped.
Not prepped, and she's got the background. So, all right, thank you, and I won't see you. Well, I might see you tomorrow.
Yeah, I think you do, actually. I think I'm in tomorrow morning, I think. But if not, have a good holiday.
All right, you too. Thank you. Ms. Campfield, I hope we can make some progress with that young man, but he's got a long way to go.
All right, friends, let's change it up. We're going to go to Reno, which is always a good time, but it is not Shelley O'Neill today. It is Judge Chris Hazlitt Stevens. So let's see what's going on there.
Linda Teresa Coonrad.
Coonrad, thank you very
Yes.
much. Did you watch the video this morning that contains your rights, Ms. Coonrad?
Yes, I do.
Did you understand the rights and the penalties associated with both misdemeanors and contempts of court?
Yes, I do.
And did you have sufficient time to speak with Mr. Hartzell, your attorney, this morning?
No, I have not.
Mr. Hartzell, can you remind Ms. Coonrad that you had a conversation? Maybe this will refresh her recollection a little bit.
Hello, ma'am. We did speak this morning, and Your Honor, I do have similar competency concerns. These are several vagrancy, indigency charges, and based on that, I will submit as to competency. Thank you.
All right, thank you. Ms. Coonrad, do you know where you are this morning?
Yes, I'm in Reno, Nevada.
You know where you are within Reno, Nevada, ma'am?
I'm in the court system.
Okay. Do you know what day of the week it is right now?
Is it December 9th?
Do you know what year it is?
Oh, what day is it? Tuesday or Wednesday?
All right. Do you know what year it is?
3012 or something?
All right. So I have similar concerns. First of all, those concerns were raised by counsel, and that already places Ms. Coonrad's competency in question. I have further concerns based on my colloquy with Ms. Coonrad. Therefore, pursuant to NRS 178-405, I'm suspending all proceedings against Ms. Coonrad pending a competency evaluation. She will be ordered to submit to a competency evaluation. I'm going to place Ms. Coonrad on a no bail hold pending that competency evaluation, and we'll return for a competency hearing when those results are given. Thank you, ma'am.
Thank you very much.
Okay. And then we just have a few more cases before we get to Ms. Bailey. Shadrick Flores.
Yes, sir.
Good morning, sir.
Morning.
Sir, did you watch the video that contains your rights this morning?
Yes, I have.
Did you understand the rights and the penalties associated with misdemeanor charges?
Yes, I do.
And did you have sufficient time to speak with Mr. Hartzell?
Yeah.
Great. In this case, this was a community court case where you allegedly failed to appear for a case status hearing. Allegedly, you failed to appear on October 22nd of this year at community court for a status hearing. Do you understand that?
Yes, sir.
Do you wish to admit or deny failing to appear on that case status?
I admit.
I accept your admission. I'll find you in contempt. Counsel, I'm inclined to just close this matter up unless anyone has objections.
Your Honor, I just thought it was a suspended sentence for community service. Is that right?
Yeah, 8 hours community service with conditions comply with community court.
We'll submit it, Your Honor.
Thank you. Mr. Hartzell, you okay with
I'll
that?
submit as well. Yes, Judge.
All right. Mr. Flores, what I'm going to do is convert that 8 hours of community service to 1 day Washoe County Jail. Credit time served, all conditions waived. This case is all closed up, sir, okay?
Thank you.
Good luck to you. Thank you. Next matter we have is Sonia Green, aka Sonia Lutu.
Hi.
Good morning, ma'am. What is
Hello.
your true and correct name?
My name is Sonia Green.
Sonia Green. All right, Ms. Green.
Yeah.
Ms. Green, did you watch the video this morning that contains your rights?
Yes, sir.
Did you understand the rights and the penalties associated with both misdemeanors and contempts of court?
Yes.
And did you have sufficient time to speak with your lawyer this morning, Mr. Hartzell?
Yes, I did.
Great. We're on record in case number 24, CR 15721. In this case, you were charged with trespassing at the Atlantis Casino. This alleged to have occurred on November 30th of last year. Do you understand that charge?
Yes.
Allegedly, you failed to appear at court to answer to that charge. That failure to appear alleged to have occurred on January 7th of this year. First, do you wish to admit or deny failing to appear on January 7th of this year?
I admit.
I accept your admission. I will find you in contempt. How do you wish to plead to the crime of trespassing?
I'm guilty.
Do you understand that by pleading guilty, you'll be waiving your trial rights?
Yes.
You understand that means there will be no trial in this case and we'll proceed to sentencing this morning?
Yes, sir.
Are you a veteran of the military?
No, sir.
I'll accept your plea of guilty. Mr. Altum, anything from the city?
Looks like she was arrested yesterday. I'll submit it, Your Honor.
Thank you. Mr. Hartzell?
Thank you, Your Honor. With credit for time served, we'd ask to close out. Thank you.
All right, thank you. Do you know if Ms. Green is held on other charges, counsel? Or is this the only thing that brought her into custody?
Your Honor,
Deputy?
he had a case out of Reno Justice. She was being released on that and they found this warrant.
Okay, perfect. Thank you very much. That's exactly what I wanted to know. Ms. Green, anything you wish to say?
I have a family at home and I would like to attend to my family.
Oh, okay. So you have a place to live when you're out of custody?
Yes, I do.
That's good.
Yes.
Okay, I like that. I'm going to go ahead. This is an old case. We're over a year deep into this case, so I'm fine. Go ahead and time serve you on this case. This case is all closed up. And so if nothing else is holding you, you ought to be released, okay?
Thank you, sir.
Back to your family.
I like your blue eyes.
Thank you. I appreciate that, ma'am.
Sonia, grab a seat.
Okay.
All right, Donald Newman. Mr. Newman, good morning.
Good morning, Your Honor.
I'm pulling up your case now. Sir, did you watch the video that contains your rights this morning?
Yes, I did.
Did you understand the rights and the penalties associated with misdemeanors?
Yes, I do.
And did you have sufficient time to speak with your lawyer this morning?
Yes, Your Honor.
We're on record in 25 CR 18704. You were charged with trespassing. This alleged to have occurred on December 16th of this year at 407 North Virginia Street. That would be the Silver Legacy Casino. Do you understand that charge?
Yes, sir, I do.
How do you wish to plead, sir?
No contest.
Do you understand that by pleading no contest, you also will be waiving the constitutional trial rights you heard in that video?
Yes, Your Honor. I do.
Understanding that there will be no trial in this case, we'll proceed directly to sentencing this morning.
Yes, sir.
Are you a veteran?
Yes, I am.
When did you serve, sir?
15 June of 76 to 15 June of 2004.
You served that entire time in the military?
Yes, sir. Yes, sir.
You're a lifer. You, that's impressive. What branch, sir?
Air Force. Sir,
Are you retired military?
yes, I am.
Thank you for your service, sir.
You're welcome.
All right, I'll accept your plea of no contest, find you guilty of the charge of trespassing. Mr. Alton, please.
Your Honor, just to make sure, this is Mr. Newman?
This is Mr. Newman.
Okay, thank you. I'll submit it.
All right, Mr. Hartzell, please.
The trespass was incidental, Your Honor. He was unaware that the row was the conglomeration that it is.
Yeah.
We discussed an overall stay away from casinos approach, and he was very nice to deal with. I did not discover that fact of his prolonged service during my canvass of him, so I'll submit as well. Thank you.
Thank you. Mr. Newman, anything you wish to say? You're not required to say anything if you don't wish to.
No, Your Honor, I'm fine.
Stay away from the row properties. So that would be the Silver Legacy, Circus Circus, and the El Dorado Casino. Because now that they've trespassed you,
Yes,
they've 86'd you from all three properties. So if you go back there, you're just going to be right back in custody, and you don't need to be in custody.
no, sir, I do.
You're all
not.
connected with the VA, sir?
Yes, sir, I am.
Time served. Thank you.
All right, you have a great day, Your Honor.
Thank you.
Your
You too,
eyes
sir.
So am I.
All right. The last matter we have before Ms. Bailey is Kashwan.
Question Sheridan, yes, sir.
Thank you. Good morning, sir.
Good morning, sir.
Thank you for the help. Sir, did you watch the video that contains your rights this morning?
Yes, sir.
You understand the rights and the penalties associated with misdemeanor charges?
Yes, sir.
And did you have sufficient time to speak with your attorney this morning?
Yes, sir.
We have three matters with you. They're all trespassing and all at Renowned Casino. I'm going to go on record. 25 CR 15210, trespassing alleged to have occurred on October 11th of this year at the Renowned. Do you understand that charge?
Yes, sir.
25 CR 17773, trespassing alleged to have occurred on November 22nd at Renowned. Do you understand that charge?
Yes, sir.
And finally, 25 CR 15928, trespassing alleged to have occurred on October 25th of this year, also at Renowned. Do you understand that charge?
Yeah, I was aware of it, but technically when I was transported in the ambulance, I didn't know that they was going to take me to Renown. They didn't ask me.
Okay. Is that only that one back in October?
Yes.
Thank you. Mr. Altum, how'd you like to proceed? We have three trespasses, same location, and we have that one that's he was transported to Renown.
Usually
Hang on, sir. Mr. Altum, does the city have any position, or do you want me to canvass on all cases?
I would ask him to plead to the two other ones. I would
Okay.
dismiss the one, and then we'd go to sentencing.
All right, thank you. Mr. Sheridan, the city has offered that if you plead to the other two cases, they will dismiss that one that's the questionable that you say you were transported on. Is that an offer you would like to accept, sir?
Yes, sir.
How do you wish to plead in 25 CR 15210 trespassing on October 11th?
Guilty.
Do you understand that by pleading guilty to this or any other charge this morning, you'll be waiving those trial rights you heard in the video?
Yes, sir.
You understand no trial and we'll proceed to sentencing?
Yes, sir.
Are you a veteran?
No, sir. I have family that's veterans though.
All right, thank you, sir. I'll accept your plea of guilty on that case. Let's go to the other case, 25 CR 17773. This was a trespassing alleged to have occurred on November 22nd, Renown. How do you wish to plead to that one?
Yes, sir. I would like to plead guilty.
I'll accept your guilty plea on that one, and I will dismiss 25 CR 15928 in exchange for those two pleas pursuant to negotiations. All right, Mr. Alton, does the city have a position on this?
Yeah, Your Honor, he's been in since the 12th. He has some more serious charges in Reno Justice Court with a pretty high bond, $6,000 bond on 7,000 total bond, and then none on one. So credit time served doesn't seem appropriate, and on these cases, it doesn't seem he's going to be getting out anytime soon.
All right, thank you. Mr. Hartzell?
I'll submit, Your Honor. Thank you.
Thank you. Mr. Sheridan, anything you wish to say before I sentence you on these cases?
No, sir. I just wanted to say I hope you guys have a great holiday, and I'll pay whatever fine or whatever duties I have obligations to these fines, and I will go to St. Mary Hospital.
Would you please?
Yes.
Yes, listen, Renown, for whatever reason, you have some desire to go back to Renown and they don't want you there. So don't go to Renown, stay away from Renown. Now, listen, it's tricky with hospitals because you have an absolute right to get emergency services at a hospital if you need them. But otherwise, stay away from Renown, okay?
Yes, sir.
Time served on both cases. Good luck on your other matters.
Thank you.
You're welcome. All right, now we have our regular docket. We will handle Alyssa Bailey first.
Good morning.
Good morning, Ms. Bailey. All right, Ms. Bailey, did you watch the video that contains your rights this morning?
Yes.
Did you understand the rights and the penalties associated with misdemeanor charges?
Yes.
And did you have sufficient time to speak with your lawyer this morning, Mr. Hartzell?
Yes.
We have three matters with you ultimately, Ms. Bailey. 25 CR 12085. In this one, Department 1, Judge Draculich imposed 30 days in the Washoe County Jail on October 30th of this year and suspended that sentence for 1 year. Conditions: obey all laws, no alcohol or drugs without a prescription. Also, he ran that consecutive to another case that I'm going to talk about right now. 25 CR 15068. 30 days suspended, 1 year, same date, October 30th. Obey all laws, no alcohol or drugs without a prescription. I do want you to know that if you're convicted of any new crimes, including these new charges you face, you could be found in violation of those suspended sentences and possibly have to serve that time. Do you understand that?
Yeah.
Okay. Let's go to our new cases. We're going to be on record in 25 CR 18587. In this case, you were charged with 2 counts of violating an extended protection order against domestic violence. These charges alleged to have occurred on December 14th of this year in the area of 10656 Walton Park Drive. Do you understand those charges?
Yes.
How do you wish to plead to those charges, please?
No contest.
Counsel, are we pleading no contest?
Or
Just 1 second, Ms. Bailey. Mr. Hartzell, is this going to be a no contest? And if so, we need a waiver.
I have a waiver.
I just saw Deputy O'Connell emailed a waiver at 8:58 a.m. I don't know if the court had that before then. And just for the record, the parties a couple days ago had agreed she will enter a plea to 1 count of the EPO.
Thank you, counsel. I appreciate that. And I am now looking at a waiver of rights for an extended protection order. So I'm going to go through this waiver. All right. So Ms. Bailey, it sounds like you are going to enter a plea to 1 count extended protection order this morning. Is that your understanding?
Yes.
Okay. And the other count will be dismissed. Is that your understanding as well?
Yes, sir.
Before I accept your plea, I want to make sure you understand the elements of that charge, the constitutional trial rights you'll be waiving by entering your plea to that charge, as well as the possible penalties, okay?
Yeah.
Just 1 second, I'm trying to pull it over to my screen that I want. All right, Ms. Bailey, I want you to first understand that you have a constitutional right to have a speedy and public trial by entering a not guilty plea. Do you understand your right to trial?
Yeah.
At that trial, you would be entitled to be represented by an attorney. And if you could not afford one, I would appoint counsel to represent you at no cost. Do you understand your right to counsel?
Mm-hmm.
Yes?
Yes.
At that trial, it would be the city's burden to prove each element of the charge against you beyond a reasonable doubt. That is the highest burden in the law. If they were unable to meet that burden, you would be acquitted. That is found not guilty. Do you understand that?
Yeah. Yes.
Okay. Here, the city would be required to prove that on or about December 14th of this year in the area of 10656 Walton Park Drive, you violated an extended protection order against domestic violence. Do you understand that those are the elements the city would be required to prove in order to convict you of this charge?
Yes.
Also at that trial, you'd be entitled to confront and cross-examine the city's witnesses. That's your Sixth Amendment right you hold. You would be entitled to call your own witnesses to that trial and use the subpoena power of the court to compel their appearance and have them testify on your behalf. And finally, you would enjoy the right to remain silent at that trial. You could not be compelled to testify. If you chose to remain silent, neither I nor any other judge would be able to hold that against you or take any inference from that in any way. Do you understand those constitutional trial rights?
Yes.
Do you understand that by entering your plea of no contest to this charge, you'll be waiving those rights, meaning there will be no trial and will proceed to sentencing?
Yes.
A no contest plea will have the same legal effect as a guilty plea in that if I accept your plea, I will make a finding of guilt and you will suffer a conviction for this charge. Do you understand that?
Yes.
Extended protection order crimes are enhanceable, and any prosecuting agency will use this and any other constitutionally valid prior to enhance the penalties on any subsequent similar crime you commit. Do you understand that?
Yes.
Let's go over the possible penalties. For a first offense, it's like any other misdemeanor, up to 6 months in jail and up to $1,000 fine. Do you understand that?
Yes.
Do you also understand that I can impose a no contact order relative to a suspended sentence?
Yes.
Second offense is a gross misdemeanor that's punishable by not more than 364 days in jail and a fine of not more than $2,000. Do you understand the penalties for a second offense?
Yes.
Third offense is a category D felony, punishable by a term of not less than 1 year, but not more than 4 years with the Nevada Department of Corrections, and fines of not less than $1,000, but not more than $5,000. And I want you to know probation would not be available to you. Do you understand the penalties for a third offense?
Yes.
You're represented this morning by attorney Trevor Hartzell. Have you had sufficient time to speak with Mr. Hartzell about this case?
Yes.
And are you satisfied with his services relative to this matter?
Yes.
Is anyone forcing you to enter this plea this morning?
No.
Has anyone promised you anything in exchange for entering your plea?
No.
I want you to know that the attorneys will be making sentencing recommendations, sounds like to me this morning. I want you to know that I will consider their recommendations, but I'm not bound by their recommendations, and I can, if I see fit, sentence up to the maximum penalty, which is up to 6 months in jail and up to $1,000 fine. Do you understand that?
Yes.
Are you an active member or a veteran of the U.S. military?
No.
The conviction for violating an extended protection order may have negative immigration consequences related to admissibility, adjustment of status, removal, and or denial of citizenship if you're not a U.S. citizen. Do you understand?
Yes.
I'm looking at a document called a waiver for extended protection order violation. It appears to have the initials A.B. on this document. Are those your initials?
Yes.
Did you place your initials on this document?
Yes.
And did you sign this document on the final page?
Yes.
Ms. Bailey, did you read and understand the contents of this document before executing it?
Yes.
This document does just what I've done here in open court with you this morning. Again, it goes over the elements of the crime, the rights that you waive by entering your plea, as well as the possible penalties. Ms. Bailey, do you have any questions either about anything that's contained on that waiver of rights or about anything I've gone over here with you in open court this morning?
No.
Therefore, how do you wish to plead to count one, violating an extended protection order against domestic violence alleged to have occurred on December 14th of this year?
No contest.
Factual basis, Mr. Hartzell?
Yes, Judge, we stipulate.
Thank you. Ms. Bailey, I find your plea to be knowing, voluntary, and intelligently entered. I will accept it, and I will find you guilty of that charge. I will affix my signature to this waiver of rights form, and I will dismiss count 2, same charge, violating an extended protection order. Looks like we can go forward to sentencing, Mr. Altum. Why don't you go ahead and start?
Governor, on the 2 revocation cases, those were consecutive. Is it disorderly conduct for that case? That was essentially going back and reviewing that case. That was, I mean, could have been seen as an attempted residential burglary. She's trying to enter into somebody's home. They arrested her on disorderly conduct for whatever reason. That wasn't like a normal disorderly conduct where somebody's, intoxicated yelling in the street or something. She was trying to actively enter somebody's home. So she did get a suspended sentence in that. The petty larceny was nearly a felony. It was $1,192 worth of information. So both of those cases could have potentially been filed as felonies. City's recommendation with this new plea is to revoke her on both of those for the full 30 days each consecutive, so 60 days total. On this new case, we'll be able to hear from Christina Bailey, her mother, but go through the new case. This seems to be have had a giant effect, negative effect on Christina and her husband Scott. It sounds like it's an ongoing long-term thing that they've done everything they can as Miss Bailey's parents. It has to be an extremely frustrating situation for them. They've had to lock up their house. Christina here on Zoom has had to quit her job to basically watch the house against her daughter. So that's all extremely unfortunate. From the city's recommendation, and again, we'll hear from Christina, see what her thoughts are, but my opinion, looking at all this and this criminal history, that she should have a mix of more upfront jail time consecutive to those other 60 days. My suggestion would be for another 60 days upfront, and the remainder of the 120 out of the 180 max, I would ask to be put in as a suspended sentence to prevent even further crimes, protect the public, protect Christina and Scott Bailey from her trying to get in the home. Even this case could be seen as a residential burglary or attempted residential burglary. So city's recommendation is for 60 days up front, 120 days suspended sentence for 2 years, obey all laws, no alcohol or drugs. Generally, in these type of totality of the circumstances, folks have some substance abuse issues. And so that seems probably likely, and Christina can inform us more on that. But all of those conditions would hopefully protect Scott and Christina. Would also ask that a no contact and stay away order be ordered as part of this case as well.
Thank you, Mr. Alton. Mr. Hartzell, please.
Thank you, Your Honor. I don't see additional jail time as extremely beneficial. Of course, we have to globalize and deal with these suspended sentences that were put in place and that the defendant was informed of prior. However, we would ask that the court consider alternative pathways, such as, for one, perhaps monitoring, GSM monitoring, more indication as to where this individual is located, if testing's appropriate, then to make sure that she's staying on the right path as to that. But and frankly, I don't see additional jail time relative to other things where she might be making progress. This is in many ways to me akin, if not with the physical action, but domestic violence classes or perhaps some sort of peaceful family classes if available. At her age and given the dynamics of the situation, I'm not, I would say that perhaps a 30-day suspended sentence being imposed, if any, would be our ask as to that, and that alternative means of sentencing be considered as to how she can best learn from this whole scenario and how it's played out. Thank you, Your Honor.
Thank you, Mr. Hartzell. Ms. Alyssa Bailey, I'm going to hear from you first. If you wish to speak, you're not required to speak right now, but if there's anything you'd like to say, now's the time. Would you like to say anything before I sentence you?
No.
Okay.
No, sir.
Ms. Christina Bailey, do you wish to speak to the court this morning?
Yes.
Before you do, please raise your right hand. In the matter pending before this court, do you swear or affirm under the penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You're sworn. What would you like the court to know, please?
This has been going on for 5 years and it's not getting better. It's gotten worse. It's gone more downhill. We do have to sleep with our doors locked, our bedroom doors locked. I had to put locks on her brother's room and her sister's room so their stuff isn't stolen. Like I said, I had to quit my job just to make sure that our house is not emptied. We were so nervous that more of our belongings would disappear. She's stolen my car twice. She has stolen my wallet, my credit cards, my debit card. She's taken off to San Francisco with it. I mean, it's not fair to us. We keep trying to help her and she doesn't want to accept the help. And she's been on cocaine, pot, alcohol. She was just here the other night trying to get in and she had a gallon thing of tequila in her hand. And then on the side of the house, we found it. It's just nonstop. And we're miserable. It's hard. It's hard.
I can't imagine your struggle. Cannot imagine your struggle. Ms. Bailey, Alyssa Bailey, how old are you, please?
27.
Do you work?
Yeah.
What do you do?
Right now I'm in between a serving job and a dietary specialist job.
Are you a high school grad?
Yes.
Any college?
Credits, but not like, yeah, I mean classes, yeah.
All right. So listen, you're going down a dark road here. You have two cases that I'm considering revoking you on, having you in jail for some time. I don't know if that really bothers you or not at this point or not. It may not. I mean, some people are in the position, they're like, whatever, I'm just gonna do my time. And it sounds like to me that the primary issue here is substance use. And with substance use, there's always mental health underneath it. But it sounds like that's where we need to go. But in order to address this, because listen, I can impose jail. I have no problem with that. And that'll keep you away from your mom and dad for a little bit of time, months only. That's about all I can do is months. Next time you'll probably hook a felony and then it'll be years, which is, you know, a relief to your mom and dad. Unfortunately, we're speaking this, a relief to your mom and dad that you hook a felony. And frankly, I don't know if, but just looking at you, I don't think you're ready for substance use treatment. Not even a little bit. I think your affect is flat, not emotional, and I don't think you really care about what's going to happen. So I'm just going to go ahead and sentence you. I was going to consider a drug court because I think that could possibly help, but I just don't think you're at that stage in recovery. So what I'm going to do is 25 CR 12085, revoke the 30 days. And in 25 CR 15068, revoke the 30 days. You'll spend those 60 days in custody. Those are run consecutive pursuant to Judge Draculich's order. In the new case, 180 days, Washoe County Jail. Suspended 2 years, you will obey all laws. You will neither consume nor possess any alcohol or drugs without a prescription. I'm going to have you test when you're released from custody. You're going to be testing for 120 days. And if you violate, you're going back into custody. You will have no contact with your parents, Christina and Scott Bailey, and you will stay away from the residence of 10656 Walton Park Drive. I'm going to have you serve an additional 30 days up front on this one consecutive. This is all run consecutive. In the event of revocation, no alternative sentence, you will be subject to search and seizure at any time of day or night, with or without a warrant, with or without probable cause at the request of law enforcement. You will submit to evidentiary testing any time of day or night, with or without a warrant, with or without probable cause, to determine the presence of alcohol and or drugs for which you do not have a prescription. When you are released from custody on these charges, you are ordered to report upon release, to sign up for supervision and start testing. That'll be this court's order. Thank you.
Thanks.
Judge, what level of testing did you want
Enhanced, please. Thank you. Thank you. Ms. Bailey, thank you. I'm so sorry for that difficult family situation you're facing.
Yeah, I just want to say one more thing, if you don't mind. I don't know if I don't think it'll go on the record now because I should have said it earlier. But she's literally got a hammer and tried breaking down my bedroom door to get in. I mean, it's scary.
Yeah, it sounds like a very, very difficult situation. Well, she'll be in custody for a little while, for about 90 days or so. And then she'll be on a suspended sentence, my suspended sentence. And if she violates, she goes back to jail.
Okay, thank you so much.
That's what we got. Yeah.
Okay.
Thank you.
Do I just
How
hang
long
up?
was she? I'm sorry to interrupt. I was gonna ask, how long was she going to be on the enhanced testing? After
120 days.
Thank you.
Yep.
Well, that's a sad situation right there. But you know what? It's also not that uncommon, unfortunately. We've seen it before. I just put up a poll. Let me know what you think of Judge Hazlitt Stevens. This is really, I think we ran across him once prior, maybe, but this is the first time we've spent extended time with him because usually it's Judge O'Neill. So let me know what you think of him. Let's 9 to 11% more Judge Boyd. Let's go there, and this will probably close out our day.
Knowles for Mr. Carter.
All right, and excuse me, the other attorney, if you can come forward. And also for Mr. Carter, if you could state your name, please.
Kyle Simpson.
All right, have both parties, I'm sorry, defense counsels, have you received discovery from the state and did you review it with your client?
We have, Your Honor, and we did.
All right, court will find that the state is in compliance with discovery. Mr. Carter, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsels, do you waive the reading of the indictment?
We do.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with the offense of publishing or threatening to publish intimate visual material as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? All right, why is everybody whispering today? All right, that's okay. It's like people are whispering for some reason. I can't hear. Court reporters having a hard time hearing. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
All right. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsels, has your client been able to provide you with any defenses?
Yes, Your Honor.
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Yes, Your Honor.
Mr. Carter, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine and the state recommends deferred adjudication. Did you understand that to be your plea?
Yes, ma'am.
Defense is at the plea?
It is.
State is at the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
Just for a moment. Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No.
Outside the
No.
agreement, thank you. Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be 100 hours community service restitution, TAP evaluation. The state has put zero tolerance. I don't do zero tolerance. You know, either you violate your probation or you didn't, and then I make decisions on that. A mental health evaluation, parenting classes, anger management class, BIP class, no harmful or injurious contact with the complainant. Did you understand that to be your plea?
Yes, ma'am.
Defense is at the plea. Defense is at the plea.
Yes, Your Honor.
State is at the plea.
Yes, Judge.
I'm sorry, not the plea. Did you understand that those recommendations are recommendations from the state and the court does not have to follow those recommendations? And those are the recommendations that the court previously read which is the state is recommending 2 years. So I don't have to give you 2 years. I can give you more than 2 years. 100 hours of community service restitution. I can give you more than that. The mental health evaluation, parenting classes, anger management class, BIP class, and the no harmful injuries contact. You understand that?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest? State any evidence.
State offers State Exhibit 1 and attachments. Without objection.
All right. And
No
state,
objection.
thank you. And state, have you spoken with the complainant?
Yes, Judge, and she's here today.
All right. Mr. Carter, did you review the waiver and stipulations of testimony with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Yes, Your Honor. We'll waive PSI.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. So this, the offense as charged, right? Whenever you see that offense on paper, you know, it gives a certain impression. Our client was in the throes of custody issues. He understands that he made the wrong decision to take his anger out in that way, rather than, you know, addressing it in a healthy manner. Mr. Carter volunteers as a football coach at a local high school. He is a former NFL player, and he is giving his talents and giving back to the community in that way. He is fully committed to continuing that path. He is fully committed to working on himself, and this incident does not define him. He is remorseful, and he's ready to change under your supervision.
All right, why is there a request for BIPP? I'm sorry, you're not the attorney on this, but I mean, was there, I understand that this is seen as a form of abuse, but isn't BIPP for physical?
Battery. Yes, Judge, and I can just imagine, because it's someone who was a spouse of his, and someone, this is not just some random person, and so
I mean, I'm not gonna order that. How old are you?
what is this?
All right, why are you threatening to send out videos?
I made a mistake.
No, you didn't make a mistake. You made a choice.
I made a choice. I made a bad choice. And didn't think why.
Like why? And why were you knocking on her door or knocking on her window? What were you expecting?
Talk about my daughter, but it didn't help at all.
Well, what time did you go to talk about your daughter? What time was it?
Late.
What does late mean?
Past a bit time, 10 o'clock, I think. Well,
All right, nobody's knocking on somebody's door at 10 p.m. to talk about their daughter or talk about their child. They're usually there for something else. Did you call her? And I see you called her and she blocked you.
this one.
All right, so it appears that she doesn't want you anymore. I don't know why people can't accept that. And it's not like you're a teenager. Even teenagers, when somebody doesn't want you anymore, you can move on. As my grandmother would say, cry on the inside. Don't let that person know they've broken your heart, and just move on.
This one.
I don't understand why you don't understand that.
If I may, I think context matters here.
Oh,
My understanding is that the complaining witness was withholding visitation from my client. And he had no way to do it. A custody suit has ensued and they're working that out. But during that time, they were breaking up.
So why would he go over her house after 10? Why not go over there at lunchtime? Why not go over there during, daylight time?
I think he was frantic, Your Honor. And he understands, right?
I want to find out if he was frantic. He hasn't told me anything.
We're at the wrong way.
No, but I mean, why go to her place at 10? And the reason why I'm asking you these questions, it's so I can determine whether or not all of these extra conditions that the state is asking, whether or not that's appropriate.
Because at the time I was allowed to come over there and the time I was so serious and I thought we could go over there.
What do you mean you were allowed to come over at any time?
No, because I used to go over there like to see my daughter. I leave to go home by 8 before she go put in bed. And all of a sudden then she got mad at me and then she blocked me and I was just talking to her and I just went over there and I should have went over there.
Mm-hmm.
That's when the custody thing came up in after the fact.
So what family members do you have in San Antonio?
I moved out here just for my daughter.
To co-parents.
To co-parents.
From Alabama.
Well, we were trying to get together. I bought a house here and we're not together, so I'm stuck in San Antonio for myself. And I only got here about my daughter here. That's it. I don't have no family.
So how do you all discuss childcare issues? What is happening with that? Is it through the app?
Right now, we've been talking to each other on the phone, and my daughter got a watch, and I've been hanging out with her when she allowed me to see her. Taking me to eat. Supposed to be going to see the light show tonight, so I mean, if I've been contacting
with the complainant and the daughter.
Right.
So they're amicable.
Within both of us.
Well, here's the thing. People hang out with each other and then they think things are great. And then maybe they'll decide that they're going to get back together. You shouldn't do that because whatever issues y'all had previously, these same issues are there.
Judge, he also has a daughter that's 17 that is in the state championship as a wrestler in Alabama. She's already not committed, but she's been offered a full ride to the Naval Academy. So we'd ask that he be able to travel freely between Alabama and I guess Annapolis, right? Should that be where she commits?
All right. So what I can tell parties, I don't know why people get in relationships and then they have this issue with the children where people are not letting people see each other, not letting people see their children. But this is what I can tell you. When a relationship is over, it's over. Don't try to get back in that relationship. You and the complainant are supposed to be adults and everybody's supposed to be putting their children first.
Yes, ma'am.
And when people hurt the mother of their child, the father of their child, just being petty, then you're hurting the child. Do you understand?
Yes, ma'am. I understand.
And I can tell you, until things were explained to me, I was close to giving you jail time as a condition. But now I'm able to see everything and the state was not asking for jail time as a condition.
Judge, again, context, complaining witness and my client went to the same school, Troy University, Alabama. And he played football for the school and she was an athletic trainer, correct?
Yeah, I've been on a lot.
So it's an on and off relationship for 20 some odd years. Is that right? 6 years.
It's been a while.
Then the baby came along and tried to do the right thing, moved to Texas to co-parent, and things happen.
All righty. This is what the court is going to do. Court is going to sentence you to 2 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. The coaching that you do, are you paid for that?
No, ma'am.
Okay. So
I don't get paid for it.
all right. So there's to be no there's to be no employment as a home health care provider or with minors. There's to be 100 hours of community service restitution. Ms. Abrams, if you verify that he's actually coaching, that can count towards his community service hours. Field visits 1 time per month for 3 months. And the complainant is requesting the no harmful or injurious contact.
Yes, Judge, and the idea is for the child custody and transferring.
All right,
There-
there's, yes.
One issue, he has total and permanent disability with the NFL, and so he's not allowed to work for that.
He'll need to provide proof of that.
Okay.
All right, so proof of employment within 40 days or proof of inability to work. And the court will require an anger management class. And I'll require a parenting class. Probation, is there anything else? Oh, I'm sorry, I wrote it in, but I didn't say it. No harmful or injurious contact with the complainant. Right. Is there anything else that you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, if you complete everything early, the court will consider early termination.
And Judge, I may have not on it, but did you allow travel?
Miss Abrams? He's allowed to travel to events with his other daughter. So he's allowed to travel to out of state. Because maybe they're gonna go to another wrestling tournament other than Alabama.
And is that just particularly to his daughter, Your Honor, or can it be also, he has an elderly mother because that lives in Alabama, he helps care for, he's the only child that can care for her.
All right, you all will just need to approach on that. Your attorneys will need to turn that over to probation.
Oh, thank you.
Okay.
Thank you.
All right, Vashon, just go ahead and say he's allowed to travel out of state for his child and also for his mother. And there's to be UA upon return. So that'll be a UA within 24 hours. So if you leave and you come back, it'll be the UA the next business day. And you can either do UAs or either you can do the patch. The patch costs more, but with the patch, probation will just put a patch on you. You don't take it off, don't tamper with it because that'll be a violation of your probation. They will pull it off and then they'll test it. All right, did you review the trial court did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we're off the record. They're saying they have a victim impact. Basically, what ends up happening is the complainant speaks to you. I require that everyone is respectful to each other, and usually the complainant will tell you their feelings on this offense. Do you understand?
Yes, ma'am.
Great, thank you. So if you'll stand over there and the complainant will remain seated.
Oh, okay.
Yes.
And that will be that because she never airs victim impact. And it's time to call it a day anyways. But we'll be back tonight, 8 p.m. Eastern, 5 p.m. Pacific for the last sidebar of the year. So please do join us for that. We're going to talk about some of our favorite cases from the year or cases that have garnered our attention but maybe weren't our favorite, or we'll just see where it goes. But do join us for that. And we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific for the last morning show of the week, so do join us for that. Go have yourselves a good Thursday. Look forward to seeing you all tomorrow and hopefully tonight. Take care. God bless.